Item numbers 1 and 2, RSA 170 of 2022 and RSA 172 of 2022.
Would the appeal allowed?
Item number 3, bail application 1776 of 2025.
Petition dismissed.
Yeah, please, Lordship. Lordship, I'd like to mention for listing of RSA, my lord.
When?
Tomorrow, Lordship.
For what
Urgent
purpose?
Urgent interim order paid for Lordship.
Pardon?
Urgent interim order paid for Lordship. RSA, my lord. One I for stay operation, my lord.
No, on Friday. Oh no, sorry. Thursday we'll try.
My lord, another CRP also there, my lord.
Another?
CRP, my lord.
When?
Civil revision petition.
When?
Before vacation, my lord.
Is there any agency?
Yes, my lord.
After vacation, also one case we have already given.
What urgency is there?
Because there are one interim order, my lord, which we want to stay
Interim order in?
in, my lord, in another case, my lord, which is registered as
Okay, on
money
Friday we'll try.
money
on
execution, my lord. There are attachment of property, my lord.
So you can mention. Can we direct that the matter may be listed in the vacation bench?
Vacation.
On who is there? Not notified. Okay, vacation bench.
Vacation bench. But can it be because, my lord, there are attachment of property order, my lord. Property of petitioner is attached by the court, my lord, in money execution case. That's why we are forwarding the CRP petition, my lord. His only vehicle is attached by the court, my lord.
On Friday we'll try.
My lord, oblige, my lord.
May I please, Lordship? Lordship, I'm praying for listing of the CRP on day after tomorrow, Lordship, on Thursday, 26th, Lordship. It was filed on 11th. And the object was there.
Tomorrow.
Yes, day after tomorrow, because the next day is fixed on 29th, Lordship. There's a prayer for stay of that proceeding, Lordship. Thursday, Lordship.
May it please, your lordship. I would
Yes,
like to mention this item for listing, lordship, because the Bakijai proceeding is started, lordship. And can it be on Thursday, lordship, for orders? Highly obliged.
May I please, your lordship? Withdrawal of appeal matter.
Pardon?
Withdrawal of an appeal matter. I'll list tomorrow matter.
Tomorrow, not
Lordship
possible.
for withdrawal. For
Withdrawal matter.
Withdrawal.
Withdrawal.
Please, your lordship, I would like to mention for the MSc appeal, your lordship.
When?
Listing of MSc appeal.
When?
Uh,
After vacation?
vacation
the vacation.
Take a date for me.
on 18th July.
Yes.
With my lord's permission, may I mention item number 26, which is the last item of the day. On 29th of April, this matter was directed to be listed at 2 o'clock. So if my lord is kind enough to take it up at 2 o'clock today.
Okay.
29 April was the last day. It was directed to be listed at 2 o'clock today. But whereas in the cause list, it is the last item of the day. So if it is taken up at 2 o'clock to be
Okay, we will upgrade it.
one mala,
We will upgrade it.
Okay. Okay.
2 o'clock.
Okay. At 2 p.m.
Deep level.
Transfer petition for listing, lordship.
When?
It is coming up on first before in the vacation. We are filing yesterday, lordship. Lordship, this Thursday or Friday.
After vacation. After vacation.
But because the date will come.
Maybe you file an application there. Because already a lot of cases have been fixed before vacation. So we are unable to accommodate all of you.
All right.
Yes.
Lordship. Lordship, I beg to mention I in make appeal, which is may be listed on tomorrow, Lordship. Very urgent, Lordship.
How it is urgent?
Execution proceeding is initiated against the insurance company, Lord.
Let it be
For-
only
for
after
Lord.
vacation we will list it. After vacation, not before vacation.
The matter is urgent, Lordship.
Maybe. Yes.
May it please, your lordship. I beg to mention one CRPIO for withdrawal, lordship.
When?
Tomorrow. Lordship, there is another matter, one IA in RSA, lordship. we want to extend the injunction order passed by this court, Lordship. The matter may be
When?
listed tomorrow.
Tomorrow,
Tomorrow may not be possible.
Friday.
Obliged, Lordship.
Briefly, Lordship. My lord, item number 10, Lordship.
Ah.
In that case, the Honorable Court directed us to file additional affidavit. We have filed that, but that is not on record. The matter may record.
Okay,
can
call
be-
it. Yes.
Please, look, not a pray for listing of an CRP method. It's a school of 1951 method taken by the government on 60. Execution is pending on first method. And our petition under order 21 rule 97 has been dismissed as not maintainable. Saying that as the disposition has not happened, therefore there's no cause of action for entertaining the application. And apparently, my lord, the Patadars were not made a party. And it's a school, my lord, established in 1951 and taken by the government in 1960.
Hmm.
School, my lord, otherwise will be prejudiced.
So after the vacation, because
First it is fixed for execution.
when the execution case was filed,
When it was filed long back, we filed an application, the objections were heard, and thereafter the court came to a conclusion that as the disposition has not happened, therefore 97 is not maintainable. Whereas, my lord, there are judgment of the Honorable Supreme Court that 97, even before disposition, can be filed.
okay,
Friday.
Friday.
May it please your lordship. Lordship, I beg to mention item number 7, Lordship. Matter may be adjourned for today, Lordship. The English Council S. Sharma is not well today, Lordship.
Your good name, please.
You, Sir Gary, Lordship.
Miss so learned counsel appearing on behalf of Mr.
Miss S. Sharma, Lordship.
Miss S. Sharma, learned counsel for the respondent.
Petitioner.
Item number 7.
Yes, Lordship.
Okay. For the respondent. No, for the petitioner. Price for listing the matter when?
After vacation, Lordship.
After vacation. Where
Obliged, Lordship.
you
Wait,
some private parties are there. You obtain consent from them?
Yes, Lordship.
With
Consent has
consent
been
from the
obtained,
other
Lordship.
side.
May it please your lordship. I'm paying for 3 identical matter, Lordship. Lele annotation appeal, Lordship. After vacation.
Yes.
May it please his lordship, I am praying for listing of a transfer petition, lordship. In the court below, the matter is fixed on 9 July, lordship. May fix before vacation, lordship.
Before vacation, not possible.
Lordship, in the
After
court
vacation,
below,
maybe you file an application there.
My lord, against the injunction order passed by the appellate form, my lord, I file a revision petition, my lord. I have been affected. I will be affected.
After vacation, not before vacation. After vacation.
may
Yes.
I please your lordship. Lordship, I beg to mention item number 8, lordship. Lordship, my senior some personal difficulty, lordship. Kindly adjourn for the delay.
Miss, your good name?
R. Dev, my name is not here, lordship. I'm
Learned
appearing on
counsel
behalf
appearing
of
on
Mr.
behalf of Mr.
S. Chauhan.
As so on, learned counsel for the appellant. You inform the other side?
No, lordship. Her name is wrongly listed, lordship.
B. Chauhan.
B. Chauhan.
This is in the motion column or
Yes,
admission
Lordship.
column?
Motion.
Admission column. Okay. Place for listing the matter after vacation?
After vacation.
Fair law.
May I please,
Obliged,
your lordship. I beg to mention is for listing for orders 2 MSc appeal. After vacation on.
After vacation.
May it please your lordship. Lordship, I beg to mention item number 17 and 21. Hearing items.
17 and 21.
Yes, the concern of the other side has already been taken, your lordship. I'm making this mention on behalf of Mr. PJ Saikia, your lordship.
Mr.
PJ Saikia, your lordship, senior.
PJ Soikia, learned counsel appearing on behalf of?
No, I'm appearing on his behalf, your lordship. I'm
Mr.
making
your good
a plea
name?
for adjournment. KJ Saikia, your lordship.
KJ Soikia, learned counsel appearing on behalf of Mr. PJ Soikia,
17
learned
Article.
conducting counsel for the appellant. With consent from the other side, price for listing the matter. When?
In the month of August, your lordship, if possible, on
In the month of August.
14th of August.
14th.
They are allowed. You inform the other side?
Yes, your lordship.
Okay.
Hearing.
Mr. Som, you are there.
Lordship, in item number 21,
21 as
respondents.
respondent number 2.
As respondent 1 and 2, lordship. And one
Respondent
cross-
number 1 and 2. Okay. That what is right. Yes.
Deeply
One RSA for listing on 22nd of July. It's the matter is of 2015, and another is of 2016 on 24th of July, my lord. obliged.
May I please, your lordship, I beg to mention for listing of one FAO, lordship.
When?
Lordship, this is an urgent matter. The earlier this honorable court directed to for ex parte injunction for hearing in the lower court, lordship, and in that injunction was rejected, lordship. And after that, lordship, we have filed this FAO.
When do you want?
Lordship, I want to list it for lordship Friday, lordship.
Friday already, lordship.
Is there urgency?
Urgency,
How?
lordship, because this is a tenant lordship.
Sure,
tenant-
Friday we'll try. Yes, sir.
For listing of an interlegal application, my lord.
For?
What when, my lord, in the execution proceeding has been started before the lower court, and executive court had fixed the matter on 10th of July, my lord. For appearance and report.
Okay, after vacation.
Friday kindly, my lord.
No, not possible. After vacation.
After vacation, if my lord decrease.
No. Immediately, the decree will not be executed.
That is true, my lord. But after passing of the judgment of the honorable appellate court, my lord, these executing courts are very hurry, my lord, in India nowadays.
Definitely.
My lord.
Definitely.
That is why my lord perception, my lord.
Immediately after reopening.
On
Okay,
14th
Take it
July.
from him.
14th.
14th.
Yes.
May it please, Your Lordship. Your Lordship, I would like to mention for listing of an CRP.
When?
On Friday itself. Before.
Is there any urgency?
Yes, sir. The
After vacation.
Yeah.
Take it from him.
On 14th July. Okay. Items from daily list for motion bail application, item number 4.
So this is the second time bail application, Your Lordship. Earlier, it was rejected on 7/2/2025, Your Lordship, at page 47, Your Lordship. The relevant part at page 51, Your Lordship. There, the ground was basically for delay, Your Lordship, which was not accepted, and accordingly, it was rejected. Lordship, the petitioner is behind bars over 441 days, Your Lordship.
What is the ground for filing this second application?
Lordship, the number of days, Your Lordship, as well as it has come to our knowledge that the section 50 CRPC notice has not been duly served.
Section
Mentioning the grounds of arrest, Your Lordship. As well as, Your Lordship, there are 11 witnesses, Your Lordship. The trial has not commenced yet, Your Lordship. The charges have been framed only on 5/3.
Mr. K.J. Soikia, learned for the accused. Sir P.H. Law for learned additional technique for the respondent. This application under section 483 of the BNSS 2023 is prepared by accused Santosh Setri and Srimati Rekha Setri, who are languishing in jail in connection with NDPS case number 38 of 2024, arising out of Lekhapani PH case number 21 of 2024, under section 21C or 29 of the NDPS Act. Mr. Soikia, learned counsel for the accused, submits that the second application is preferred on the ground that while effecting arrest of the accused persons, the IO has not communicated the ground of arrest to the accused persons. In order to appreciate the submission of learned counsel for the accused, perusal of the case record and the case diary is found to be necessary. And accordingly, it is provided that case itself call for a scanned copy of the record and also the case diary from the court of learned additional session judge. You can get application number 1. Margarita. Come special judge and DPS Margarita Pinchkin. Fixing the matter on
14 July.
14th of July.
Item number 5.
May it please, Your Lordship. Lordship, petitioners are before Your Lordship for the second time, Lordship. Earlier rejected, Lordship. Offense, Lordship, under section 21C and 29 of the NDPS Act, Lordship. Trial is going on, Lordship. Main ground, Lordship,
How
is
many
that
witnesses have been examined?
witnesses, Lordship. Trial has fairly progressed, Lordship. Out of 11 witnesses, 9 have been examined, Lordship.
And now the new ground is that non-furnishing of lordship ground of arrest, 50 and 50A lordship of the notice, the CRPC lordship. Nothing was mentioned, lordship.
Heard Mr. N. Hassan, learned counsel for the accused, and Mr. T. Bortakur, learned additional PP for the state respondent. This bail application under 6483 of the BNSS 2023 is prepared by four accused, namely Salma Begum, Dhanmaya Setri, and Umari Setri, and Tulan Hazurika, who are languaging in jail in connection with NBPS case number 18 in bracket 3 of 2023 under section 21C stroke 29 of the NBPS Act since 1/12/2020. Mr. Hassan learned counsel for the accused submits that this second bail application, second or third?
Second.
Second bail application is prepared by the accused on the ground that while effecting arrest of the accused persons, the IO has not communicated the ground of arrest to the accused persons. In order to appreciate the summation of Mr. Hassan, learned counsel for the accused, perusal of the case ID and the case report is found to be necessary, and accordingly, it's provided that this is a call for the scanned copy of the record and the case ID from the court of learned special judge NDPS Act in Sukia. Fixing the matter on.
This is the 16th July.
Lordship. Obliged.
Item 6.
My lord, it is a transfer matter filed by the wife praying for transfer of the divorce case, which has been filed by the husband in the family court in Dhupuri, my lord. My lord, in Dhupuri, my lord, the family court, personal appearance of the parties are necessary, and the respondent is also residing of.
Why personal appearance are necessary?
In family court, my lord, there is no my lord, advocate's requirement is not there, my lord. The parties are to be present in person in all the matters, my lord. And secondly, my lord, the mother of the petitioner is suffering from cancer, my lord. That specific statement given at paragraph 11.
That what is this that proceeding is pending?
For divorce, my lord. Husband has filed this divorce case.
I am asking at what is this that proceeding
Appearance,
is
my
pending?
lord. Appearance. On 5th of 5th, my lord, July, date is fixed, my lord.
Third, Mr.
T. Chakraborty, my lord.
Learned counsel for the petitioner. This petition under section 34 read with section 151 of the Code of Civil Procedure is referred by the petitioner for transferring FC title so T number 8 of 2025 pending before the Court of Learned Principal Judge Family Court ruling. The learned counsel for the petitioner submits that the husband of the petitioner, the respondent herein has instituted the divorce proceeding before the Principal Judge Family Court at Dhuri, and that the petitioner resides at Guwahati.
Guwahati, my lord. And the husband is also working in Guwahati, Apollo Diagnostic, my lord. That specific statement I have given, my lord.
The respondent herein is also residing in or working in Guwahati. Working in Guwahati, and that the mother of the petitioner is suffering from cancer. And the petitioner has to take care of her, and as such, it would not be possible on our part to contest the proceeding before the principal Judge Family Court at Dhuri. And on such ground, the learned counsel for the petitioner contended that the title suit number so and so may be transferred from the Court of Principal Judge Family Court at Dhuri to the Principal Judge Family Court, Kamrup, Guwahati. The submission of Mr. Chakraborty learned counsel for the petitioner needs further consideration at this instance. Notice be issued to the respondent returnable in forwards to be taken by registered post with ATM also by usual process. Taking note of the submission of Mr. Chakraborty learned counsel for the petitioner and also considering the fact that the record. Further proceeding of the FC titles of number T of 8/2025 stands state till returnable at this type of province.
I'm deeply obliged.
For admission, item 9.
Doctor, can it be passed before the timing also?
Item 10, bail hearing.
My lord, in this case, you are also directed to file an affidavit because there was some.
That affidavit is not received by the courtmaster till after some time.
After some time, there was.
Item 11.
May I please, your lord? Scan copy was called for lordship. This scan copy was called for lordship in this case, but I think lordship scan copy has been received, lordship.
Pardon?
Scan copy was called for lordship, LCR lordship. I think lordship that has been received, lordship.
Received, yes.
Yes, yes, lordship. Lordship, I paid for granting bail to the accused Sahib Tahani, lordship. In this case, lordship, he is languishing in jail.
NCB?
Lordship, we need time to file our objection.
Pardon?
We need time to file our objection.
Lordship already two quick.
This was filed in the on 12 of June 2025. So ask Mr. Kyle to remain present after some time.
12 for orders.
May please, your lordship. Lordship, service upon respondents are complete, lordship.
Service completed?
Yes, service completed, lordship. It may be fixed for hearing, lord.
Hearing. LCR received.
LCR is received.
Received. Third Mr. PK Das, learned counsel for the appellant and madam.
For one only.
Learned counsel for the respondent number 1.
Copy of network that will be furnished.
Will furnish.
None appears for the rest of the response. They submitted at the bar that service has already been completed and LCR has been received and the matter may be listed for hearing. Accordingly, it is provided that President shall list the matter for hearing in 21 after immediately after 5th of August. 5th of
Obliged, lord.
Item 27 orders.
Yeah, please, your lordship. My lord, regular second has been, appeal has been filed, my lord, against the concurrent finding, my lord. But in that appeal, my lord, 19 days delay is there. So, lord,
19
notice
days
page.
delay.
Yes, madam. So, notice page. K. Singha.
Case in a learned counsel for the petition. No, for the applicant, this interlocutory application under section 5 of the Limitation Act is required for continuation of delay of 19 days in filing connected regular second appeal against the judgment and decree dated 38/4/2024 and 7/6/2024, respectively, entitled appeal number 23 of 2023. Passed by the learned civil senior division number 1, Kamrup M. Guwahati. And the judgment and decree dated 28/3/2023, passed entitled suit number 256 of 2021, passed by the learned Munsip number 4, Kamrup M. Guwahati. Let notice be issued returnable and for which step be taken by registered post with AD and also by legal process.
My lord, we may be allowed to take the notice to trustee, my lord, because the execution proceeding is going on, my lord. So there is some urgency, my lord.
Learned counsel for the petitioner. Returnable after 2 weeks then.
My lord.
Learned counsel for the applicant further submits that he may be permitted to effect service upon the respondent by the stipend. Here is allowed after effecting service upon the respondents by the stipend, the learned counsel for the petitioner shall file an affidavit.
No, my lord, matter will be kindly fixed after immediately after vacation, my lord, if possible. My lord.
After 2 weeks, definitely they will list it.
My lord, there is some urgency, that's why, my lord.
For hearing item numbers 13 and 14, Partha Patel.
Please, Your Lordship. Your Lordship, I pray for some accommodation, Your Lordship. Conducting council has some difficulty, Your Lordship. So I pray that this matter may kindly be adjourned for the day, Your Lordship. Any date after vacation, Your
After
vacation, any date?
24th of July, Lordship, because this is a 2017 matter, Lordship.
Yes, Your Lordship.
24th of July. Good vote.
29.
As agreed by learned advocates of both the parties, this is a later matter on 29th of July.
Obliged.
Item 15.
Legs. After some time, my lord. The argument is almost completed, my lord. I will argue on the judgment shown by him. That was 16 medical report. And medical report also.
Please, Your Lordship. Lordship, in this case, Lordship, yesterday we filed one IA, Lordship, for substitution of legal heirs of appellant number 4. That may be take. It's not on record.
License record.
Then, Lordship, after
Vacation.
Lordship,
Heard, Mr.
M. Hussain.
Learned counsel for the appellant and Mr. H. Kuragumai, learned counsel for all the respondents.
All the response.
The learned counsel for the appellant submits that he has filed one interlocutory application for substitution of legal heirs of appellant number 4. Appellant number 4. But the same is not placed on record. Accordingly, it is provided that race is a list the matter on data that it. 2010
7th August.
Sorry.
31st.
2010.
31st. Right.
Including the interlocutory application with the record.
Deeply obliged.
Item 18. Item 18.
On a case for the appellant on call. The record reveals that on P6/2025 also the appellant remain absent. Recessal list the matter immediately after reopening. And in the event of subsequent non-representation of the appellant, appropriate orders will follow.
Item 19.
Lordship, can it be taken up after some time? Because I have another matter. I'll do it. Hello, Blake.
Item 20.
If Lordship, this regular first appeal is preferred by the appellant plaintiff against the sole respondent defendant. In this, both plaintiff suit was dismissed as well as the counterclaim of the defendant respondent was also dismissed. The defendant did not contest, the respondent did not file any appeal as against the dismissal of the counterclaim. Therefore, only my appeal lies. My appeal is before this honorable. Before I come to this honorable court, it was that I like to bring to this, kindly look at this exhibits, exhibited document, exhibit documents, exhibit 2 and exhibit B, same document. Exhibit 2 filed by the plaintiff, exhibit B filed by the respondent, defendant. It is the same document on which my entire case rests upon it.
Exhibit?
Exhibit B or Exhibit 2. Exhibit 2 filed by the appellant plaintiff and Exhibit B filed by the respondent defendant. Lordship got it.
Is it an advocate notice?
Yes, Lordship, not advocate notice. His name is the Biplab Kumar Setia.
Yes.
Exhibit B. It is the same document exhibited by the defendant also Exhibit 2. Exhibit B. Plaintiff appellant has filed the document as Exhibit 2.
Yes.
Address to Executive Engineer PWD BRC Badorpur. Construction of IBB cum roads, including security fence along with the right bank of River Suroma from Kanegari Khal to Harinagar, BP, so and so, so and so. It is to be Sir, it is for your kind information that Sri Prasanta Kumar Saha of Silsor is authorized to act as an agent. Here the plaintiff is the agent. For execution of the above work, in this connection, he is authorized to act as authorized to act as follows. Actually, it should have been as follows on behalf of me. To take all arrangement for execution of the work and to engage man, material, machineries from his own. This is very important. To attend departmental inspection site work and to meet all of the directions and instructions and departmental officers. To receive checks for payment of bill in favor of me. To receive store materials if issued by the department for this work. Here it shows a copy was given to this Prasanta Kumar Saha for information necessary action. This was addressed to the office. Copy was given to me. I also exhibited the same document. He also exhibited the same document. It is the only document on which the entire case raised upon. On the basis of this, I carried out the job. Now here the case, landed trial court dismissed my suit on the point that yes, what I got it is a different issue, but I did not have any agreement with the defendant to act upon. So my submission before this honorable court will be this is an agreement. If you don't take it as an agreement, this is an agent. In that case, the section 182 of Contract Act will play. 182.
Okay.
Lordship, (182) as well as Section 70 of the Indian Contract Act. What 70 says? Obligation of a person enjoying the benefit of non-gratuitous act. The plaintiff appellant is also a contractor. He carried out the contractual works on behalf of defendant respondent. Contractual job was entrusted to defendant respondent, and he could not carry out because there was a lot of problem, land acquisition problem, etc. And he is a local boy. It was entrusted to him. Accordingly, he has been even paid 50 lakhs rupees. Subsequent works, what we have carried out, that my payment was not made to me. It was for 70 or 57 lakhs. With interest, it comes as 71 lakhs. So my job 70, but the landed trial court, he clarified yes, that money which I got it, rightly I got it. Because defendant's plea was that it was only a financial assistance given to me. 50 lakhs rupees. However, the landed trial court rightly decided the issue, yes, not 50 lakhs was not paid as a this one, it was paid as against my job. But remaining amount, 57 lakhs, it was not paid to me. The entire bill amount, 2 lakhs 48 lakhs, 2 crore 48 lakhs was taken by the defendant plaintiff. My suit was for only 57 lakhs, remaining amount to be unpaid amount. So this I claim it on the basis of the section 70 and 182 of Contract Act.
What 182 is that about?
182 is agency. What is agent? Why agency has been defined? Because I have been clearly shown that I am an agent. An agent is a person employed to do any act for another or for represent another in dealings with third persons. The person to whom act is done, who is so represented, is called the principal. So I was doing the contractual job on behalf of the defendant, respondent, the principal one. And I have been paid on the basis of Exhibit B or oblique Exhibit 2. This is an admitted document. Because this document has been exhibited by both the parties. The content of the Exhibit 2 will go in toto. It was clearly said that I am going to work as an agent. I'll spend the money from my pocket, carry out all the contractual works.
If the learned trial court has held that you have been rightly given 50 lakhs,
50 lakhs.
then why the
Remaining amount, he said that I do not have written agreement with the defendant.
Then what basis you have received the earlier 50 lakhs?
On the basis of the said document only. And this has been admitted by him. His plea was that this was given to me as a financial assistance.
Is there any clause in the agreement?
No. The agreement is the Exhibit B. I say that even if it is, no, we don't take it as an agreement. It is an authority given to me. And I am covered by the 182 of Indian Contract Act. And Landed Trial Court, instead of deciding the issue under Section 70 of the Indian Contract Act, he decided the matter in the 73 of the said Act. Compensation for losses caused by the breach of contract. I say that I do not have written agreement or with the defendant. But I have the document to show that I was asked to work for him. And there is no document to show that he carried out the latter part of job. I have exhibited number of documents, vouchers, in support of my 57 lakhs. That is exhibited from Exhibit 6, Exhibit 6, Exhibit 7, Exhibit 8, Exhibit 9, Exhibit 10. On the basis of these documents, because again I had to contract assistance of other people. Assistance means I had to engage other people for soil filling, earth filling, taking tippers, taking JCB on rent, then using purchasing materials, the petrol, diesel, then labor payments, which I carried out. Now, his plea was that he paid me 50 lakhs as an financial assistance. But this Landed Trial Court has rightly decided that he should know it was not given as one, he was given what was due for him. But Landed Trial Court decided the matter under Section 73 of the Indian Contract Act. What 73 says, when a contract has been broken, I said contract has not been broken. There is no document to show I have withdrawn from the contract. The party who suffers from such breach is entitled to receive from any party who has broken the contract compensation for loss or damage caused to him thereby, which necessarily arose by as usual course of things or breach. The Landed Trial Court stated that there was no written agreement. Even there was no written agreement, it is an implied agreement, oral agreement. And to that effect, Exhibit B, Exhibit 2 clearly speaks. And on the basis of Exhibit 2, Exhibit B, I received rupees 50 lakhs from him. And by dismissing the counterclaim, his plea that he gave me as a financial assistant did not survive. And the document which he has exhibited as Exhibit C onward, Exhibit C onward, is also a receipt payment. Exhibit C, D, E, F, G, H. So also speaks that I received that amount from him. This is an admitted one. I have filed my bank statements. London Trial Court has said that that the statement was not proved. Even though it is by document, he did not say that it was not, this money was not given to me. So that is admitted one that I received money, my 50 lakhs from him. By way of cash, by way of check, by way of draft, or by even by money transfer, by CC account transfer. Now, if Lordship comes to that cross portion of the TW1, as regards to the awarding the contract by the PWD, there is no dispute. We do not have any grievances as against the department, because job has been given to defendant. He carried out the job through me as an agent. And accordingly, I received 50 lakhs. I have got to receive another 57 lakhs. With interest, 71 lakhs. Lordship got it?
Yes.
Plaintiff Prasanta Kumar Saha was known to me earlier. I have been awarded with a contract by PWD Border Roads for bid price of rupees 2,48,33,396 rupees. Filed work order dated 16 May 2005. Filed Exhibit B. This is the document which I talked about, Exhibit 2. I engaged the plaintiff for execution of the above work, and he was authorized to, one, to make arrangement for execution of the work and to engage men, materials, machineries from his own. This is very important. To attend the departmental inspection of site work and to meet up all the directions, instructions of the departmental officers. To receive checks for payment of bill in favor of me, to receive store materials issued by department for work, filed exhibit for work, filed Exhibit C to Exhibit L. I have paid rupees 50 lakhs 20,000 to the plaintiff on various dates by way of cash, by way of check, on by way of CC account, and same is admitted by the plaintiff also. And the reasons for such payment is mentioned in my Exhibit C to Exhibit D. I did not remember how much was final amount paid by PWD, the border roads, to me at the time of completing the said work order dated so and so. And the same was completed in the year 2012. I have not filed any document to show the said work order was completed in the year 2012. It is not a fact that the plaintiff completed the work as per as an agent authorized by me for total amount of rupees 1 crore 7 lakhs. This was the job which I say that I have completed the job for 1 crore 7 lakh 76,000. It is not a fact that I am yet to pay rupees 57 lakh 56,000. I have not filed any bank statements to show that the amount which I received from the PWD border roads in connection with the work order. I sent a letter to Executive Engineer PWD BRC by Exhibit B. Exhibit B does not contain any terms and conditions to show that the plaintiff was not allowed to work after my time, after some time. This is important. Exhibit B did not say that you work up to this portion, thereafter your agency job is over.
You are reading DW.
Already, Lordship.
DW1.
DW1. This not by cross
Examination
my
for the shift part.
shift part. He has only exhibited these three. What is the exhibit 1 work order Exhibit 2, Exhibit A, work order, Exhibit B, what is the, Exhibit B, which is Exhibit B is Exhibit 2, a common document, admitted document. Exhibit C to H regarding the payment made to me regarding 50 lakhs rupees. Lordship got it. I sent a letter to the executive engineer PWD BRC by Exhibit B. Exhibit B does not contain any terms and conditions to show that the plaintiff was not allowed to work after some time. My submission before this honorable court is that all along on the basis of Exhibit B or Exhibit 2, I continued to work as an agent for an amount of rupees 1 crore 7 lakhs something. I have been paid 50 lakhs, 56,000, but I have not been paid remaining amount of 57 lakhs. A copy of the Exhibit B was also given to original to the plaintiff. This was the question that he raised in our cross-examinations, that your Exhibit B you have not filed earlier. But all right, this document is already given to me and he has exhibited. There is that means disputes if authenticity of this document Exhibit B or Exhibit 2 can no longer stand. I used to complete the various bank transactions arising out of my business, including this state work order at my banks at Guwahati. I have not filed any documents to show various execution works, orders by way of man, material, machineries at the time of carried out by plaintiff as authorized by Exhibit B. That means there is no document. He did not file any document to show that, yes, even if he claims that the job was carried out by him, latter part, there is no document to show that he engaged any such persons or machineries to complete the job. It is not a fact that I am yet to receive 50. It is not a fact that
Mr. Bhagavati, that the evidence in SIP of DW1 is available, but I have not seen in the cross-examination part here.
Lordship,
Have you gone through the record?
Procedure
Print it
DW1.
out.
DW1 is there.
Okay. Lordship, it will be important
Can you
because
show me from the document or from the record?
Lordship.
But it has to be in the original record.
It is their Lordship. Lordship, it is there.
Yeah.
Okay. 37. Page 37. Así, nada. মোৰটো সোমাল নেকি কিবা সোমাই গ'ল মোৰটো সোমাইছে I think all of my record is also must have come there. All of my record is also there. আপনার তো ল'ব পাৰে তাতে দিয়ক Lordship, Plaintiff, Lordship got it. Plaintiff Prasanta Kumar Saha was known to me earlier. I have been awarded with a contract by PWD Border Roads for a bid price of rupees 2 lakhs 33,000 some. The work order dated 16 May 2005. Fight Exhibit B, I engaged the plaintiff to work for the above work, and he was authorized to 1. To make arrangement for execution of the work and to engage man, material, machineries from his own. This is important. To attend the departmental inspection site work and to meet all the directions, instructions of the departmental officers. To receive check for payment of bills in favor of me. To receive store materials issued by the departmental store for work order. Exhibit C to Exhibit L, I paid rupees 50 lakhs to the plaintiff on various dates. Buy of cash, buy of check, or buy of CC account. And same is admitted by the plaintiff also. And the reasons for such amendment is mentioned in the Exhibit C to Exhibit L. I do not remember how much was the final amount paid by PWD Border Roads to me at the time of completing the said work order dated 16 May 2005. And the reason was the same was completed in the year 2012. I have not filed any document to show that the said work order was completed in the year 2012. It is not a fact that the plaintiff completed the work as an agent authorized by me for total amount of rupees 1,07,76,699. It is not a fact that I am yet to receive. Here is the word, it should have been, he is yet to receive, not he, I, it should have been he. He is yet to receive rupees 57,56,000. I have not filed any bank statements to show that the amount which I received from PWD Border Roads in connection with the work order. I sent a letter to Executive Engineer PWD BRC by Exhibit B. Exhibit B does not contain any terms and conditions to show that the plaintiff was not allowed to work after some time. This is my, because it is all along on the basis of Exhibit 2, Exhibit B. I completed the work for an amount of rupees 1,07 lakhs. And the copy of the Exhibit B was also given original to the plaintiff. I used to complete the various bank transactions arising out of my business, including the said work order at my bank at Guwahati. I have not filed any documents to show the various execution works by way of man, material, machineries on the same was carried out by plaintiff as authorized by me, Exhibit B. That means he did not have any document to show that he carried out any job other than me. It is not a fact that I am yet to pay rupees so and so. It is not a fact that I am yet to pay the demanded amount by the plaintiff. So my submission before this honorable court is that I am governed by section 182 of Indian Contract Act, and I am covered by 70 of said act. Section 70, section 182, 187. Agency was, it is an implied one. It is an implied agreement. Even if there was no oral agreement or written agreement, it is an implied agreement that I continued to work with him as an agent. And the plaintiff himself is a contractor, class 1 contractor. This document we have given. And exhibit A, exhibit 1. As per section 222 of said act, agent is to be indemnified against the consequences of lawful acts. The employer of an agent is bound to indemnify him against the consequences of all the lawful acts done by such agent in excessive authority conferred upon him. So I am conferred upon the authority by Exhibit 2, Exhibit B. Accordingly, he paid me 50 lakhs rupees. Thereafter, I filed various vouchers to him But he refused to pay remaining 57 lakhs with interest 71 lakhs. Now, I like to leave two judgments. So my submission before this honorable court, I rely upon Exhibit 2, Exhibit B. Second is that I am an agent under Section 182 of the Indian Contract Act, and I'm liable to be indemnified by the defendant respondent under Section 222, and I'm governed by Section 70 of the said act again. Section 70 also speak the same thing, not by Section 73. Even after in Section 73, what they said that what the London Trial Court has said that I did not have any written agreement with the defendant respondent that he engaged me so and so. Engagement, those things are not required as long as I am continued to work as an agent. So I have a good strong case by the London Trial Court dismiss my suit as well as dismiss his counterclaim also. As against the counterclaim, no appeal was preferred. I like to leave two judgments of this, all judgments. Year 1962, civil appeal number 286, supplement 1958, Bengal.
Which paragraph you have relied upon?
I like to, the entire case relates to my case also. In the very first para itself, it says that the appeal is by special leave arising out of the suit filed by the respondent B, K. Mondal and Sons against the appellant state of West Bengal in the original site, and the Calcutta High Court claiming rupees 90,000 rupees for works done by the appellant. The claim was made out in two ways. It was alleged that work in question has been done by the respondent in terms of contract entered between the parties. As such, the appellant is liable to pay amount due to the said works. In the alternative, it was alleged that if the contract question was invalid, then the respondent claim fails upon Section 70 of the contract, and the respondent has lawfully done such works, not intending to act gratuitously. This is very important. I was not employed as an agent or gratuitously. I have done job. The gratuitous part is very important. I did not give any voluntary service to him. So my submission that since he engaged me by Exhibit 2, Exhibit B as an agent, and since he paid me rupees 70,000, 50 lakhs rupees with for the works done by me, but he failed to pay the remaining works for which I have exhibited the documents, Exhibit 6 to Exhibit 10, my vouchers, etc. I have given one of PW3 who supported my case because he was again a subcontractor under me who supplied the soil, etc. So therefore, I have a good case for my compensation, rupees 71 lakhs. The principal amount is 57 lakhs. Lordship, if I am in a position to convey, satisfy this honorable court, because my case was dismissed under Section 70 of the Contract Act, stating that I did not have any agreement with the defendant respondent. Therefore, but the London Trial Court clearly said the amount which has been paid to me, 50 lakhs, was not a loan assistance to me. Even if my bank statement is ignored, rejected, even then, I have a document to show that I spent money and I completed the job. He did not file any document to say it was done by him.
Mr. Chaudhary? So Bhagavate, you have submitted that you will submit 2 decisions, but you have submitted only 1 decision.
Only one decision. Oh, is that Ascend? Lordship, I'll in that case, I'll see and file it later on today itself.
Okay.
I'll file later on.
May I please? Here in this case, the plaintiff filed the suit for recovery of a certain amount of money. Now the learned trial court, while deciding or dismissing the suit, frames certain issues. But my learned friend has not gone to the issues, so I'm referring to those issues. Now the basic issue which has been taken into account by the learned trial court, whether the plaintiff is entitled to recover an amount of rupees such and such, 71 lakhs 95,903. And whether the amount of rupees 50 lakhs 20,000 received by the plaintiff from the defendant is an interest-free financial assistance to the plaintiff, if so whether the defendant is entitled to a decree for realization, because the counterclaim was there. Now, with regard to the first issue of issue number 2, the present appellant as plaintiff, when he had filed the suit, he exhibited various documents. Now, at the time of exhibiting the documents, because certain documents, Lordship knows it very well, the merely exhibiting is not the proof of the contents of the document. Now he proved by exhibited certain documents. These are all vouchers. If you wanna kindly see the deposition part of the PW1, he has made mention about in paragraph number 13 about certain particulars in deposition of PW1. Have you got it?
Yes.
The deposition of PW1, I'm not going to other aspect of the matter. This is stated to paragraph number 13. I state that during the period of 2006-2008, I carried out the entrusted work to me as an agent by the plaintiff. Various bills were raised and payment of receipt in particular said is as follows. So he has mentioned all the vouchers. What 10 lakhs, 50 lakhs, 12 lakhs, and all these things are there. But where from he has collected and how it has been collected, and what is the contents, the proof of those documents, there is no discussion with regard to that. Because the vouchers which were issued by those concerned persons, they were also not called before the learned trial court to depose about the genuinity of those documents. So there is mere exhibiting is not the proof of the contents of the documents. So learned trial court, while taking note of that particular evidence and discussing the issue with regard to the entitlement of the plaintiff, in issue number 2 and 4, I am just reading that particular finding of the learned trial court. Issue number 2 and 4, Lord.
Please tell.
PW1 is Prashant Kumar Shaha, the plaintiff. His evidence shows that he has reiterated the claim. PW1 identified the registration certificate as Exhibit 1. Defendants later dated 1/4/2008 as Exhibit 2. Plaintiff later dated 10/5/2008 as Exhibit 3. Agreement, plaintiff's bank statement, vouchers of supply, soil, lubricant, man, machinery, JCB, tippers, etc. as Exhibit 6 to 9. Miscellaneous vouchers as Exhibit 10 put to cross-examination. PW1 admitted that there was no agreement between him and the defendant, and there was no internal agreement with the defendant regarding subcontract. So this is important, Lordship, because if there is no agreement between the parties, how the amount is to be quantified and how the amount is to be calculated with regard to the entitlement of the plaintiff. So with regard to that, there was no contract, written contract with the plaintiff by the defendant. So PW1 stated that he has not furnished any document to show that amount received from the defendant is in terms of the subcontract. PW2, Prabir Kumar Shaha, father of PW1, deposed, corroborated his son's testimony. In his cross-examination, PW2 stated that the defendant asked his son to carry out the construction work, and the entire discussion took place at defendant's house in his presence. PW1 admitted that Exhibit 2 does not disclose the plaintiff is a subcontractor, was allowed to carry out as an agent of the defendant for execution of the work. PW3 Muhammad Salimuddin Borbuya 2 corroborated PW1's evidence put to cross-examination. PW3 stated that he does not know anything regarding the agreement of subcontract between the plaintiff and the defendant, but the plaintiff told him about the subcontract to never verify from the defendant. So that was the communication he had received from the plaintiff because he had no personal knowledge with regard to the contract. PW3 stated that he supplied the materials as per the order of the plaintiff. DW1 Biplab Kumar Chetia substantiated his written statement in material particular DW1 deposed that he had paid defined amounts of money totaling such and such. He made about the claim that it was paid as an interest-free loan. Now, Lordship, the relevant portion, it is paragraph number 21 as page number 14. The evidence on record, more particularly of PW1, however, does not show there was any mutual understanding or offer and acceptance or mutual consideration or good faith between the plaintiff and the defendant in respect of the execution of work for construction of IBP route, including security fence along the right bank of the river Surma. PW2 deposed that in his presence the discussion took place between plaintiff and the defendant at the latter's place. But mere meeting between the plaintiff and the defendant cannot be construed to be an agreement of verbal nature when there was no understanding or offer and acceptance of work. So this is important, Lordship. There was no understanding or acceptance of work. Exhibit 2 only shows that the plaintiff was authorized to act as an agent for making an all arrangement for execution of the above work. Hence, it cannot be inferred that there was a verbal agreement between the plaintiff and the defendant as regards to the execution of any work, not to speak of execution of work for construction of IBB road, including security fence along the right bank of river Surma. Now, the exhibited documents with regard to vouchers, Lordship, it has been discussed by the learned trial court. Moreover, Exhibit 6 to 9 series do not in any manner disclose it. The defendant has a contractual liability towards the plaintiff. Exhibit 6 to 9 series only show that various supplies issued vouchers, money receipts in lieu of goods supplied to the plaintiff at the construction site. These exhibits 6 to 9 series do not bind the defendant so as to reimburse the plaintiff. Because this is the important thing, Lordship. There is no countersign of the defendant, nothing of that sort with regard to this particular contract that materials were supplied. So these documents are not taken into account by the learned trial court while passing the judgment. And mentioning that these are not admissible in evidence as it is not in accordance with section 28 of the Banker's Book of Evidence Act. And when the plaintiff's mode of proof of entries in Banker's Book as envisaged under section 4 of the Act is absent, no liability can be placed on the defendant. Moreover, as per section 73 of the Indian Contract Act, when there is a breach of contract, the aggrieved party can claim compensation for any loss or damage caused to him, which naturally arose in the usual course of things from such breach. Neither the plaintiff nor the evidence of PW revealed as to how and in what manner the plaintiff sustained loss or damage on account of breach of contract, as there was no valid contract between the parties. Hence, in absence of valid contract and for all the forgotten reasons, I have the considered opinion the plaintiff is not entitled to recover any amount of money. So this is the thing, Lordship. There is the certain documents as vouchers were exhibited, but it has not been properly proved as per the procedure of law. So these documents are not taken into account. If these documents are not taken into account, the plaintiff had failed to prove his entitlement or the liability of the defendant with regard to certain breach of terms of the contract. So the learned trial court, taking into account the evidence of the PW1, because the PW3, he was a person who said that I came before this court or the learned trial court and deposing that on the basis of the information that I have received from the plaintiff. So there is no personal knowledge on the part of the PW3 with regard to the execution of work handed over by the defendant to the plaintiff. So there is no as such evidence to substantiate the fact that there is any liability or there was any liability on the part of the defendant to make that amount, to pay that particular amount. Now, here in this case, Lordship, the plaintiff has made a mention that he had executed the work and he had engaged laborers, he had engaged certain machineries, all these things are there. And he has mentioned that because of that particular engagement, and he has spent substantial amount of money and so he is entitled to indemnify by the defendant. Now, the fact is that how he has proved all these things, there is no mention in the evidence, there is no documentary proof, and that has never been proved in a proper way to establish the fact that these are the laborers who are engaged, these machineries were engaged or employed for execution of the work. So in that view of the matter, Lordship, the learned trial court rightly held and this particular issue with regard to the entitlement of the petitioner, the plaintiff or the appellant, and accordingly dismissed the suit, stating that he has not been able to prove by way of any cogent evidence with regard to the his entitlement so far as the claim amount is concerned. And in the appeal also, my learned friend has made a mention with regard to section 82 of the Indian Contract Act. The Indian Contract Act of 182 is that with regard to the agent and is a person, the definition of agent, and this with regard to the person employed to do any act for another or represent another in dealings with third person, the person for whom such act is done. So it is only with regard to the definition of agent. So this particular section is otherwise not applicable. And so far as section 222 is concerned, the Indian Contract Act, the employer of an agent is bound to indemnify. Now, to get that particular thing, to take the help of that particular section, now the plaintiff is to prove how he has to be indemnified and how he has sustained the loss. In the plaint or in the evidence also, there is no record or there is no whisper with regard to the fact that he has sustained loss with regard to that much of amount. Because if the written contract is there, then we can understand that with regard to execution of work, you are entitled to this much of amount. But there was no written agreement, written contract as such. Now it is upon the plaintiff, or the burden lies upon the plaintiff to establish the fact that he has to be indemnified because of the fact he has sustained loss. And how he has proved the loss? He has not been able to prove the loss with regard to that much of amount which has been mentioned in the bill. So the learned trial court
You
has
come to the cross-examination
Yes.
of this PW1.
BW1.
No, sorry,
DW1.
DW1.
Yes, Lordship. To receive the check for payment of bill in favor of me to receive stored materials issued by the department for the work by exhibit to exhibit, I paid rupees such and such to the plaintiff on various days by way of cash, by way of check, and by way of CC account. The same is admitted by the
No,
plaintiff also.
You see, by exhibit B, I engage the plaintiff for execution of the above work.
Exactly, Lordship. No, there is no denial because the learned trial court is also saying that is the reason why the claim of the defendant with regard to certain amount of money that has not taken into consideration. Now, my submission is that, Lordship, if you are saying that you are entitled for this much of amount, how you have proved? Because merely on the weakness of the defendant, you cannot claim your right over this particular amount. You have to establish the fact that you are entitled for this much of amount. You have to be indemnified with regard to this much of amount. How he has proved? Because certain vouchers he has exhibited, but merely exhibiting is not the proof of the contents. You have to prove all these persons, bring all those persons who have to say that we have issued this amount, this much of materials you have supplied. He has not done so. So there is absolute error on the part of the plaintiff to prove his case so far as his entitlement is concerned, Lordship. Merely saying that there is some sort of exhibit is there and it is proving my right to execute certain work. We are not on there. We are saying that this much of amount he is entitled. How he has proved that? Because if I am saying that I am entitled for the 70 lakhs or 80 lakhs, something like that, then I have to prove it. This much of amount is, I am entitled for that because of execution of this much of work. I have made this much of payment and the defendant is liable for that. First of all, there is no written contract. Now, since in absence of a written contract, now the liability cast upon the plaintiff to establish the fact that this much of amount is to be paid to indemnify for sustaining the loss. And he has failed to do that. And there is a reason why, Lordship, the learned trial court has rejected dismissed the suit on the ground that these documents, the 6 to 9, are not admissible in evidence. And even in the cross-examination also, Lordship, this DW1, there is nothing on record to show that he has accepted the liability so far as the claim of the plaintiff is concerned. He has merely stated that this much of amount I paid as an interest-free loan, and that was not taken into account by the learned trial court, Lordship. So this appeal, Lordship, these particular sections are otherwise not applicable. And the learned trial court has rightly passed the order dismissing the suit because after all, you have to prove that you are entitled for this much of amount. So the documents which were exhibited, these are not valid documents substantiating the claim of the plaintiff in any manner.
The civil suit, Lordship, I don't need to prove, but if these documents are there, he did not put any question to me that this is the document you have not given to him. So I need to only preponderance of probability that yes, these documents are why I should purchase diesel for what. And the particular place is also that document clearly speaks. I don't need to prove anything else. I get it because if I purchase diesel, petrol, they'll give me the voucher. That voucher will do. Labor payment received by them, signed and give it to me. That's all. 6 to 10, I have a case. As regards to the quantum, 57 lakhs. There may be this side or that side slightly, our interest part. But I have made out a case that I need to receive another 57 lakhs. The amount of interest.
No, whether the documents exhibited by you are sufficient to establish that you are entitled to that much of amount.
Yes, I have given exactly 57 lakhs rupees. That I have given. How much I spent it, how much I purchased petrol, diesel, JCB, tippers.
In which part of your evidence you have given it?
That exhibit statements is there. I humbly submit the exhibit, exhibit para 20 of my evidence. I state that I raised various bills during that period. Exhibit 6, series of copies of vouchers, supply of soil, plant, and machineries. In my evidence. I also raised various debit vouchers for supply of diesel, petrol, higher charges of LNT 50 and so on so. 7 series of copies.
Paragraph number?
It is in my evidence. PW1.
Yes.
At page, at para 20, I state that I raised various bills during that period. Exhibit 6, series of copies of vouchers for the supply of soil, plant, and machineries. To that effect, I have given evidence of PW3. PW3 has categorically stated that he supplied soil to me. He carried out the earthwork. I also raised various debit vouchers for supply of diesel, petrol, higher charges, LNT, so and so. Exhibit 22, I engaged various men in various capacities while executing the work order. Exhibit 8 is a series of payment vouchers to the men and laborers. 23, I state that I took various machineries from different persons and paid them for their service because as per Exhibit 2, Exhibit B, he has told me that I can engage, I can take man machineries. So my preponderance, there is a strong preponderance that I have proved my case as against my remaining claim of 57 lakhs by exhibiting these vouchers. It is he to show that he did not, he failed to show that he paid me 50 lakhs rupees for doing scenic resource acts. As regards to quantum interest, I like to leave it to your conscience. How much should be the interest?
So, this 57 lakhs of 56,699 rupees does not include the interest part.
Does not include. That was the principal amount.
Principal.
With interest, it comes 71 lakhs.
And what is the rate of interest you have calculated?
18%. It is I highly, it will be more of the higher side. It will be in the higher side. 18%. That is why I said that I like to leave to your own, to your good conscience as regards to the interest part of it.
Yes, Mr. Totally, whether these documents exhibited by him are not sufficient to establish his claim by.
Lordship, even the PW3 in his cross-examination has made a mention the exhibit David vouchers by the exhibit number 6 were issued by the plaintiff and has not contained the counter signature of the defendant. So he has admitted that thing. So Lordship, kindly see the cross-examination of the PW3, the last paragraph, the middle portion.
PW1 or PW?
PW3, Lordship. PW3. What my learned friend is saying about the person who has supplied certain materials. Now he is saying the exhibited David vouchers by the exhibit number 6 series were issued by the plaintiff and does not contain the counter signature of the defendant. So it clearly nullifies the contention of the plaintiff that these documents are sufficient to establish their claim, his claim, so far as the claim amount is concerned. The last page, Lord. The middle portion, the exhibited David vouchers by the exhibit number 6 series were issued by the plaintiff and does not contain the counter signature of the defendant. So how it has been procured, how it has been created for the purpose of establishing a certain amount.
Anything more? Art Mr. Bhagavati, learned counsel for the appellant, and Mr. S.P. Chaudhary, learned counsel for the respondent. Argument concluded, order is
Item 22.
May I have your lordship? Lordship, in this case, we have filed two interlocutory applications, which are unfortunately not on record. But can this matter be taken up after the vacation?
after vacation.
Lordship. We have filed two IA. One is for the implement of the legal errors and other for condonation of delay in filing the application for implement. For substitution, I'm sorry, Lordship. So, Lordship, those two IAs are not on
Respected by
record.
learned advocates of both the parties, places shall raise the matter immediately after reopening the vacation.
Can it be on the 24th of July, Lordship?
24.
24th, 24th, 31st. Obliged, Lordship.
Pending item 50. The last occasion, I was directed to produce the medical examination report, regarding the alcoholic test. It was there in the record, because it was in Hindi, I have not. Yes, yes. Report, brief analyzer test was done, and doctor statement also available, So as per the report, actually 0.8 is a common legal limit for blood alcohol concentration rates, 0.8 means in 0.8 grams per 100 ml of blood. Now his brief analyzer test report is 1.7, more than double,
0.8 also, no?
0.8 is the common legal limit, regarding the brief analyzer test. Yes, blood or urine has not been, test not done. But regarding the brief analyzer test that is done, and that report as per that 1.7 reading.
Blood test was not done. It was the must.
Yes. And statement of doctor is available, I am reading though in Hindi. क्रमिक का मेडिकल जांच किया गया, जांच के दौरान क्रमिक शराब पिया हुआ और शराब के नशे में पाया गया. That is the statement of the doctor, and report is available. Report मतलब मैं peruse the report. Otherwise, that day, Lanet Senior has pointed out one thing that under section 11, major punishment cannot be imposed. I have pointed out that one judgment of Honorable Supreme Court, maybe in the record, or I have in the versus Gilead Singh,
That very judgment I am relying on, Lord. That very judgment. After going through the judgment, I found it helps me. There in that judgment, my lord, the charge was threefold. First, my lord, very serious charge was of leaving the campus without permission, going out drinking. Second, third was fighting with the public. That's why Supreme Court held, my lord, that is not a disproportionate. So dismissal all right.
many days, the editions of the early edition of the
Which is the judgment?
2016-13 SEC.
Part is 9?
I will accept.
This is our copy. Ask the copy also.
Okay, yes.
In that report मतलब in the judgment मतलब में previous para मतलब 20 para 20 page 11 page 15 of the judgment मतलब we respectfully agree with the said view of the opponent that under the scheme of the act in exercise of power under section 11(1) of the act punishment of dismissal can be imposed.
Yes.
So that has been answered. Well, now in the same very judgment, may come to para 22. The learned counsel for the respondent has submitted that even if the charges has been proven, the punishment of dismissal in the obtaining factual matrix is absolutely harsh. Absolutely harsh and shocking in the contents. In his submission that the punishment is disproportionate. The respondent was a part of the discipline force. He has left the campus without prior permission, proceeded to the market, consume alcohol and quarrel with the civilians. Now, in that case, when without any permission and consume alcohol and quarrel with the civilian. In the present case, consume alcohol in the sentry duty, he was sleeping and unattending his LMG rifle. In this case, though the High Court set aside the but also Supreme Court allowed the appeal filed by the preferred by the Union of India. Setting aside the order of the Honorable High Court and avail the order of dismissal. In that case, went outside the campus, consume alcohol and quarrel with the civilian. In this case, also consume alcohol in his sentry duty and unattended his rifle, LMG rifle. So, this is also a serious offense. In the same very judgment, it has been answered. And medical test, yes, though the blood or urine test was not that, but breath analyzer test has been done, and it is found reading is 1.79, 1.79, and 0.08 is the common legal limit, my lord, of blood alcohol concentration. A statement of the doctor also there, my lord, and even then, my lord, he was allowed to cross the defense because he denied that, and he has confessed that yes, I have consumed that alcohol.
That is fact, man. I have already on last occasion I submitted. Now the point here, to be point here to be decided is, my lord, very thin margin point. He in the appeal, my lord, which he submitted in paragraph 5 onwards, your lordship can see page 29 of the representation, paragraph 5 onward, that he was detailed for 3 days continuous duty. Then he, after completion of the duty, standing guard, because there was some deficiency in the force perhaps, he came back in the quarter, took bath, then he might have taken some alcohol and slept. In the meantime, command comes from, no, you will have to again go to the duty for 2 hours. He said, no, I cannot go because I am already tired and fatigued. I cannot go. Then he was asked to go because the command is command in the force, whatever the condition. He goes for 2 hours and he fell asleep. Due to tiredness and fatigueness, he fell asleep. Because he had already intimated the officer that I am continuously done 3 days duty, so I am not in a position to go. Now the question arises, what is the very crucial question to be decided is whether he drank before being detailed to duty, last duty for 2 hours, or during the duty hours. During duty hours, he cannot go out of the campus. Then that will be very serious offense under the force. Leaving the campus without permission or going out on his will, on one's will is very risky and dangerous for the force, as well as the reputation of the force. So only if he had already drunk before going for the post, then he cannot be held responsible. Because he had done 3 days duty, came back, and Malor took some wine, took his food, and was sleeping. So they are to put Malor, yes, during duty hours, he managed wine, alcohol, and drank there. Then they will serious offense. They have not done that. Although I didn't cross-examine anybody. In that evidence also nothing is there. That either he drank during duty hours or before the duty hours. Because in the post manner it is provided by the department. Some alcohol 2-3 package every day provided. They know in the army also rum is provided, not whiskey, rum is provided to keep their body hot. So that crucial point, if he had drunk before doing detail for 2 hours duty at night, then he is not guilty at all. If the order of the dismissal as well as is liable to be outright exercised. They will have to go out of the door. If he drank, if he proved that he drank when he was posted in that post manner, then he is guilty. Then also it is not that serious as that of Diler Singh's case. In Diler Singh, there are 3 charges. One, leaving the post without informing the officer or anybody in the that cannot be at any cost allowed in the post, leaving the post. Because one person to be trained, my lord, government spends lakhs of rupees. And if he is suppose kidnapped and killed by somebody in the adverse situation of terrorism and extremism. Lots of
Is there any document to show that for 3 continuous days he was on duty?
He is stated, but these are not considered by the appellate authority. What is the order passed by the appellate authority?
No. You have been asked to attend the duty, whether there was any command certificate to you.
No, it is orally, man.
Orally.
Last duty also is orally.
Orally.
Not there is no command or anything. In our environment, the appeal matter, we given the detail. Because everything was conducted in Hindi, my lord. And generally, this man from Assam, he find hard to, even there are some assistance from there. So, in the
You show me in which paragraph of your petition you have mentioned it?
my lord, come
Paragraph
to my lord, in page 29, my appeal to the department.
Page 29.
As well as in the petition also. Page
No, in
29,
appeal
paragraph 5
petition.
onwards.
Okay. Page 29.
Yes. Then page 29, Lord, then paragraph 5. Yeah, paragraph 6 also Mali has repeated there the same thing. Paragraph 5, 6, 7. It will be 8. And paragraph 10 of the writ petition, my lord.
Paragraph number
Paragraph 10 or what? Due to over exhaustion of the body for reasons of continuous duty for 3 days.
So,
prior to,
how this paragraph has been dealt with in their affidavit in
yes, my lord, that I'll show. In their evening opposition, my lord.
No, that is appeal, that is the petition for appeal, my lord.
No, appeal as well as in the writ petition also I have said. So, my lord, in paragraph 10, they have replied. Just a minute, my lord, I'm finding out.
Para 10 of the मतलब actually page 54 running page 54
54.
running page 54.
No, they have not dealt with the issue, my lord. They are simply there, the statement made in paragraph 10 with representation is denied by the authority. It is also for the stated by the respondent that authorities that the petitioner medical examinations were conducted by the medical officer. So and so it was established that petitioner consuming alcohol was under the influence of alcohol and not due to duty performed by him in quarter guard. They have not denied there was no quarter guard duty. They have not denied anywhere for 3 days. Simply denying. So that also admission matter. No, it was a statement given. And also managed paragraph 11. 11 also detail I have said. Scary eyes of the student Suzu. Even he was, they have said Malay, he was given opportunity to cross examine, but I do not find anything. In dealer Singh's case, there are three serious charges. That's what Supreme Court declined to hold it to be disproportionate. In this case, one instance, Malay, and the statement made in the appeal, was statutory appeal. That has not been dealt with by the appellate authority.
No. In this petition, they are not supposed to deal with the contention made in the appeal.
But whether the fact stated by me, because why the appeal is provided for? Why the appeal is provided in the rules? State rules. Because I am to state my case, how the impugned primary order passed by the primary authority is illegal. So that right is there in the appeal. And appeal is in the appeal it can go, the authority or the avenue court can go in the facts of the case also, not in law. And you will also kindly come to paragraph 24 and 25 of the judgment releasing.
We'll resume after 5 minutes.
Yes, sir. That's what I. Yes, ma'am. Now, my lord, first of all, I take a lordships to the judgment releasing. Paragraph 24 and 25. Why the Supreme Court held the case was not for disproportionate punishment. 24 and 25.
Paragraph number 24 and 25.
Yes. Yes, he said there were 3 serious charges, my lord. The learned counsel for the respondent has submitted that even if the charges have been
You are referring to this Dildar Singh case.
मतलब in
Dealer Singh.
judgment मतलब page para 22 मतलब this is SCC मतलब page 20 para 22 मतलब
Para 22. Okay.
I have also
Yes,
got
yes.
my extra copy. May I give extra copy, my lord?
Yes, yes.
Yes.
How much? 22 ना?
itu
mana Supreme Court
oh itu SCC juga.
No problem.
It is para 24. Same thing is there. Learned counsel for the May I read, my lord? The learned counsel for the respondent has submitted that even if the charge have been proven, the punishment of dismissal in the obtaining factual metrics is absolutely harsh and shocking to the conscience. It is his submission that the punishment is disproportionate. The respondent was a part of the dismissal force. This line starts from. He has left the campus without prior permission. This is one offense. Proceeded to the market, consumed liquor, and quarreled with the civilians it has been established that he had consumed liquor at the marketplace, and it has been also proven that he had picked up quarrel with the civilians. It is not expected of a member of the civil force to behave in this manner. In this manner. The submission, as has been noted earlier, is that the punishment is absolutely disproportionate. The test of proportionality has been explained by the court in Om Kumar versus Union of India and G. Gandha Utham versus Union of India and Dwaraka Prasad Tiwari. In Dwaraka Prasad Tiwari, it has been held that unless the punishment imposed by the judicial authority or the appellate authority shocks the conscience of the court or tribunal, there is no scope for interference. When a manner of disciplined force deviates to such an extent from the discipline and behaves in an untoward manner which is not conceived of, it is difficult to hold that the punishment of dismissal has been imposed in is disproportionate and shocking to the conscience. So here mainly the our Supreme Court was very much concerned about leaving the post matter. This is what dealt with the earlier paragraphs also. Leaving the post without informing. A member of the force must inform the commandant or the officer in control that he is leaving the post for some personal work or otherwise. And also the second very serious charge the Supreme Court took offense was matter that the quarrel with the public. A member of the force going out, drinking in the marketplace and quarreling with the public. Luckily, other member arrived there and saved him. Otherwise, he would have been beaten up badly or assaulted even grievous hurt would have been caused. So there the Supreme Court took the serious offense that in our case, yes, he has been stated in the appeal as well in the repetition. They have denied that he had no duty, 3 days duty in the video also. 3 days duty he had done. And then he was released after 3 days. He came to quarter, took bath, might have drunk, then got to and was sleeping. Then the command comes. Officer comes, the CEO comes and says, you have to again go to duty. He said no. Then he said, well, it is only for 2 hours. 79. Then you will be relieved. During the period, he feels fatigued and tired and falls down. So, unless they prove matter, the crucial point I have been repeatedly arguing is, unless they prove that during the duty hours he took wine, then offense should be a bit serious. A single offense matter, 12 years, 6 months of service that rendered without any sigma.
How many years?
12 years, 6 months. So, my lord, he may impose any other punishment. When my lord, the punishment for simple offense, not grievous offense, can be converted to the punishment of serious offense. That is, my lord, dealt in this case. Because here, my lord, he had committed 3 charges, 3 offenses. First, very serious charge. Going to the market without informing. One cannot leave the post market at any cost. In any force, even in the police force also, when they is in the campus, scheduled camp, within scheduled famous segment. That has been dealt with in earlier paragraph of the Supreme Court. Leaving the post was very serious, without informing the commandant. And second is became quarrel. Consumption liquor also may be excused. Because in post they think they are far away from the family and friends, and living in the difficult terrain and hills and unknown places. Yeah. That may also be somehow excused. But leaving the post, fighting with the public. Other fighting would have also been different. But after consumption, because in the state of consumption, state of intoxication, he fights with the public. So there is a lot of difference between my case. I've got only one incident in life. And my lord, yes, his lordship the Krishna said, he's too young to sit idle and too old to seek a new job. When he was this was 41 only, now he's 46. Beaten with family and other small. He is forced small now to do labor work under contractor. For considering all these facts, and he has ailing parents or small. Oh, sorry. Now he is 41. At that time he is 35 when the case was filed. So 41 is too young to sit idle and too old to seek job. In central government is 28, I think. Is 28. I think. Yeah, no, 28. Central government is 28. In central government is 30 years. Okay. Is the limit. So on that count, my lord also impose any other punishment because he is not harming the force as such. He is not committing anything that would damage the reputation of the force or defame the force in the eye of the public. Only here the simple was that he drank and fell down. Subject matter if they and any of the punishments one is prescribed in the in section 11 reduction rank he cannot go because he was already in that post. Beyond that there is no fine of amount or taxation so and so or confinement to quarter guard. If he has got any distinction manner, that can be removed also. Any of the punishment prescribed under rule section 11 manner may be imposed. Let him survive. The rest about 19 years of service he has got, and also his ailing parents and his family. And the certificate he has to return because in August there is a admission application. He says by tomorrow he will return. This is humble service.
The one point I would like to point out with all respect to learned senior Malad, my affidavit page 53. There are sticks, Malad, regarding Malad that unblemished service regarding this 13 years. Malad, kindly see para 6, page 53. Malad. Turning page 53, page 2 of the evidence. Para 6 second para Malad, in Malad basic training Malad, after the training Malad, while posted in Cobra, Medicine in 19/8/2015 at about 20 hours while for the night duty guard on motor. He consumed liquor, misbehaved his company commander without any provocation, poked his personal weapon with wrong intention, and for this act, Malad, considering his 10 years of service at that point of time, he was given minor punishment of 1 increment without any cumulative effect. That was of 2015. At this time also Malad consumed alcohol, cocked his rifle, pointed towards the senior, and that was proven. And considering his 10 years of length of service, Malad, minor punishment of 1 increment. Now the second Malad on this incident was occurred on the 30th of November 2017. Again consumed alcohol. Malad, he is an alcoholic person. Malad, fact is that Malad, while on duty taking alcohol or while he was going to duty taking alcohol. Malad, it's same, Malad. Before going duty, he take alcohol and went to the duty, Malad. Then for 2-3 hours, 2 hours of duty, 2-3 hours he will alcohol.
Mr. Parasar,
Malad.
so there is a submission from the counsel for the petitioner that he was allotted duty continuously for 3 days.
Yes.
In the appeal prepared by him,
Yes.
also it has been mentioned And besides, in the petition also, it has been mentioned that how do you deal with this issue?
It is continuous duty. There are
There are 10.
there are 10.
In the appeal.
But, regarding that, matlab, in regarding para 11, I have defined the section of authority related to the section of bottom right duty guard about so in the it was his prime responsibility to perform duties effectively and that on its first
Paragraph 10 of this one.
10.
In the evident reply also have repeated the same.
No. Petition.
10.
Reply of para 10 has been given in para 14 of the application. But behind the same and it is not a stated authority that the medical exemption is established as petition of consumer alcohol and was under alcohol and not due to perform this.
They have not dealt with that.
But regarding development of duty, you must, if at all he is not in a position to go on duty, he should have inform to the senior regarding that. But regarding that, no from the petitioner side also there, yes, statement is there, that continuously 3 years included. And
No, but there is no. But the denial is evasive. You have not stated categorically that.
otherwise, yes, these are the but it is that court intervention in such type of matter, if one thing is regarding disproportionate and one thing is regarding procedural lapse. In this case, there is no such procedural lapse, not giving opportunity and all this. This is not there, no procedural lapse, and one thing is regarding disproportionate.
Maybe, but under what circumstances the incident taken place that has also to be looked into.
Even then, within 3 days,
For 3 days continuous
but it
duty.
doesn't mean that when then, if at all,
Do you have any other document to show that he was not allotted duty for continuously for 3 days?
that instruction is not there. Otherwise, even then, fact is that even then, if continuous on duty, whether he will go with the consumption alcohol, he again.
Also, he denied not to go.
That denial, no such document also that he has denied that. He has to deny if proportional immediate officer, and if the immediate superior officer is not allowing, then he has to inform the higher officer also. I am not in a condition to at all go for duty. I have already consumed alcohol and thinking that I will not be altered to duty. And even at that point of time,
That would be another offense. You know, in the force, that would be another offense. If you deny duty, to go to duty,
if he is not at all in a position has been followed when personal test I have given 1.79 that is more than
That's but how far this pre-analyzing test can be relied upon? While admittedly this blood was not tested.
not tested.
Blood
Yes.
test not tested, and statement of doctor is also available.
Pardon?
Statement of doctor also available. Who appointed?
Maybe. Unless blood was tested, we cannot accept the version of the doctor
Yes.
as a gospel proof.
And prime,
It must be supported by the test, result of the test.
it's prima facie to test immediately veterinary test is necessary. Prima facie to test something immediate testing is veterinary. Otherwise, in this it should be blood or urine test.
Blood, urine is must.
There's no-
Because they had one doctor, within the campus, there was a dispensary. They had one doctor, nurse, everything. They had out.
But thing is that this is not the first instance that he has
That is gone. That was already not
Yes,
found, not
for
proved,
the
and minor punishment was given.
misconduct, I am giving his earlier occasion 2 years back, when he was consuming alcohol, pointed out rifle for that, considering his 10 years of service, one increment only that minor punishment was given.
That was not proved, my lord. They were annexed out. That charges were not proved. However,
Already
minor punishment given.
The-
Yes, and I support that. That is
No,
gone.
without the charge being proved, how can you impose
No,
punishment?
with our affidavit, we have to say that,
Whole demand, लगे थे ना.
in our affidavit, we have said that, para 6, last part, during the course of the charge level against the individual as per proof. In case 53, para 10, para 6, last 3 lines. It is during the course of inquiry, the charges level against the individual is proved. Accordingly, after taking into 10 years of long service and family problem, a lenient view was taken to award minor punishment, withholding one increment without cumulative effect. That is earlier, in 2016. After 1 year, again taken alcohol. So, his conduct, I am saying with his conduct. At that point of time, 2016, consume alcohol, misbehave the company commander without any provocation, for this personal weapon. That is also serious
Okay,
offense.
okay. Mr. Soma, this is the only judgment you have relied upon? It's Union of India versus Dilbar Singh.
Dilbar Singh, my lord.
Okay,
Because he was citing, my lord, so I wanted to cut that.
okay, okay.
Otherwise, there are a number of judgments on that. Even my lord, in Dilbar Singh also, 3 judgments have been my lord, relied on by the
Okay.
Honorable Supreme Court also.
Okay.
So, my lord, at any cost, whatever, and the earlier charge one they can bring it, then they will have to include that in the fresh charge sheet. There is bringing something from outside which is against the law. So, my lord, at any cost, my lord, he is entitled to be reinstated with minor punishment. I don't say he should be left free. He should be punished with some leniency. That's all, my lord. Obligement.
Our Mr. R.P. Soma, Learned Senior Counsel, assisted by Mr. P.N.
Yeah.
Sarma, Learned Counsel for the petitioner, and Mr. Orasur, Learned CDC for the concluded judgment in their
Obligement.
One thing, if my lord is otherwise thinking, but regarding, again, if he has to come, if that doesn't go against him, and also, he is out of the course more than 7 years. So now his medical condition, that has to be considered.
They will decide. Court cannot direct them to. That is not the purview of the question, the purview of the court. Because Lordship is
cannot
not
do it
acting
in
as the agency officer. How does it matter?
Standing item 9.
This file will remain with the case file.
Coming item 9.
My pleasure. Lordship, suit was filed for specific performance of contract along with an application for injunction. I am the plaintiff in the principal suit, my lord, and now I am the petitioner here. My injunction application was rejected. Against that order of rejection, I have come up before this honorable court. Your Honor, may come up first to page 27, my lord, to page 21, my lord. This is the power attorney given by my father to me, to the defendant number 1, who is the seller.
Page number?
Page number 21, man. IA, in IA, madam. IA.
Yes.
Page number 21, this is the power attorney given to the defendant number 1 by his father.
By?
His father. Defendant number 1, 2, and 3 are the owners of the property. Initially, the father was the owner. After his death, the 3 owners, the son, the mother, and the daughter. So the father had given the power attorney to defendant number 1, who is the son. Now, subsequently, my lord, at page 24, the father confirms in 2019 that yes, that power attorney is still valid, which was given in 2014. This is page 24, my lord, annexure 2. Now, my lord, this is annexure 3, which is most important, page 27, my lord. This is the agreement for sale, under which I possess the right to purchase the property. This agreement for sale was executed by defendant number 1 in favor of the petitioner 1, 2, and 3, who are the plaintiffs. In this, my lord, in the second page, as page 28, my lord, you will find one writing, my lord. Initially, there was an oral agreement, my lord. After that oral agreement, since my father died due to COVID, this was the COVID period, my lord, because this was executed on 16/10/2020. So during that COVID period, my lord, one verbal agreement was entered on 6/2/2020, my lord. That has been vouched in this agreement, my lord. My lord, I've got it in the first para. Last. Thereafter, my lord, what happened? After the father's death of defendant number 1, the mother and the defendant number 3, that is the daughter, they executed an affidavit indicating that I do not need any share in the property which your father left. So my lord, may get it on page 31. Page 30 is the affidavit, 31, my lord, in page para 7, my lord. We further declared that we hereby relinquish our right title interest in the above separate plot. My lord, have got it? Now, my lord, what the court opined while passing the order of injunction, my lord, may I come up directly to page 78. I'll read out, my lord. The careful perusal of the petition reveals that the plot of land measuring 4 katta 3 luchas of Dag number of Paridab katta number block number of Jorhat Moza under East Revenue Circle is subject matter of the suit. According to the plaintiff petitioner, on the strength of the one power attorney entered an agreement for sale of the petitioner pertaining to the suit referred on so and so and another agreement dated so and so. The consideration was fixed at 1 crore 30 lakhs, out of which 60 lakhs has been paid as advance. The OP number 1 has not contested the suit. The OP number 2 and 3 have denied it. They have challenged the legality of the agreement. According to the OP number 2 and 3, the OP number has no right to enter into such agreement. From the rival pleadings, I find the substantial question regarding the spectrum of right title interest, etc. involved here. If the parties are allowed to adduce evidence and they succeed in producing supportive documents and evidence in favor the respective claims, then there is a very possibility of obtaining a relief claim by the parties at the conclusion of trial based on the materials placed on record. Thus, I find that the material available on record as of now discloses existence of prima facie case. Now, secondly, in respect of balance of convenience, I find that there is no iota of doubt that the opposite party, being the legal heirs of original Patadar, Durgadhar, Hatibarua, are possession of the suit land. They have challenged the legality and validity of the agreement by the plaintiff and the defendant number one. Apparently, that agreements were executed after 6 months of the death of principal Durgadhar Hatibarua. The same are silent regarding the fact of OP number one has executed the strength of power attorney. That part, it is seen that the agreement in question do not contain any signature of OP number 2 and 3. On the other hand, being the legal heirs of Durgadhar Hatibarua, the OPs must have signed the agreement which was executed after the death of Hatibarua. Now, nowhere it has been written that OP number 1 has put his signature in those agreements on behalf of 2 and 3. All the facts clearly suggest the petitioner do not approach the court with clean hands when the pith of which the fate of the case lies is not found to be strong. Then I do not find it fit case to grant temporary injunction as prayed for. From the rival pleadings of the parties and above discussion, I find that the opposite parties will have to face more inconvenience in comparison to the petitioner if temporary injunctions are granted on the basis of agreement in question. So far as the question of irreparable loss is concerned, in the facts, and so I find the opinion two have clearly shown the ignorance about any transactions held in between the plaintiff and the OP number one. It is stated by the petitioner's side that the receipt of advance amount was acknowledged by the agreement. But when the agreement itself appears to be doubtful, then I find it unsafe to accept the contentions. Moreover, the plaint shows that no alternate relief for the refund of the advance is made in the plaint. This fact also depicts that the petitioner would not suffer for any loss or injury if the prayer of temporary injunction is rejected, which cannot be compensated in terms of money. Thus, I find that the petitioner failed to establish the irreparable loss. My lord, may come up to that affidavit. The affidavit says that we have relinquished the right. Why do I need the signature of my mother and my sister? There is a specific affidavit. They never said that they have not executed that affidavit. My lord, may come up to the affidavit, my lord. Page 30. Para 7, page 31. My lord. We further declare that we hereby relinquish our right at the interest in the above referred plot. This is the very same plot for which the agreement was entered. After the death of the father of defendant number one, this mother and the daughter said, I do not need share. You being the son, you keep it. Accordingly, I entered into an agreement. At least the property must be protected. I'll get a degree of specific performance of contract is the subject matter of the suit. At least the property must be protected. Now, suppose this 2 and 3 sells it. And otherwise also, my lord, if section 44 is taken into account of Transfer of Property Act, I have every right to sell the property. That defend number one, my lord.
Though the learned trial court has found the prima facie case,
My lord.
it has not found the other two requirements in your favor.
My lord.
So, is it not necessary to establish the same?
Absolutely, my lord. The finding of the court below is absolutely perverse, my lord. May kindly see, because it opines that the agreement appears to be doubtful. How, Lord, my lord? Since there is already an affidavit saying that I do not require the property, but on the basis of that agreement, affidavit, I executed an agreement. So that is a matter of trial, Your Honor. Once the mother and the daughter comes up and says, you being the son, I relinquish our share, you take it and you mutate it. Accordingly, I enter into an agreement. Now, subsequently, when we file the suit, when the plaintiff files the suit, they come up and say, no, we know nothing about the execution. How will you know about the agreement, about the execution? That is a matter of time. At least the property has to be protected, ma'am. Until the suit is decided.
But unless and until you satisfy the requirements, how can it be protected?
My lord, what better requirement is required when the mother and the son or daughter itself comes and says that we have no right over that property. Accordingly, I enter. I means, my lord, the defendant number one. I am the purchaser of that property, my lord. We want that the property must be protected. We do not want the possession of the property. We only say that please do not alienate the property. Please do not change the nature and character. Or a status quo order may be granted. Whatever they do, they stay. There is an open land, my lord. Nothing is there. And furthermore, my lord, may also recall section 44 of the Transfer of Property Act. Suppose, my lord, let us for a moment assume that defendant number 2 and 3 have the right over the property. In that eventuality also,
We will see and examine the matter. But we will admit the appeal.
my lord.
Third, Mr. A.K. Sayal will run it concept for the appellate. Just appeal. Under Order 43, Rule 1 RCPC is prepared by the appellants challenging the order dated 30/7/2024 passed by the learned civil the senior division Bureau in Major case number 14 of 2023 arising out of title suit number 6 of 2023. Is to be noted here that by the impugn order dated the learned civil judge senior division Bureau has refused to grant temporary injunction. First, the memo of appeal and the grounds mentioned there. Admit issue notice to the respondent, returnable in 4 weeks, shall be taken by registered court with ADN of the process within 5 days. This after 4 weeks. I will say, will examine the matter, will pass the order.
My lord, at least some
Well,
kind of,
if it is possible, we will grant it. Otherwise, we'll see.
because the fact remains, my lord, that otherwise also, otherwise, if number 2 and 3 says that we have not executed any agreement, as far as number 1 is concerned, that part of the share needs to be protected. Because 44 of the Transfer of Property Acts come into play. 44 of the Transfer of Property Act specifically states that the right has to be protected. So now suppose 2 and 3 goes. We say that 2 and 3 goes. But as far as the agreement for number 1 is concerned, that remains. Now who is going to protect that right? Transfer by one co-owner. Where one or a lot is got. One or two or more co-owners of the legally competent in their behalf transfers his share of property or an interest therein. The transferee acquires as the share or interest so far as necessary to give effect to transfer of transfers right. So my right has to be protected. I am a purchaser and a bona fide purchaser. Number 2 and 3 comes up and says that no, we have a right. You may have a right. You executed an affidavit. You said that, no, you as a son, you keep it. I accordingly entered into an agreement stating that, "ठीक है, give me the property." I purchased the property paying 130, 1 crore 30 lakhs, my lord, out of.
It is hardly to believe that they have given such an affidavit.
Maybe, my lord, it's hardly to believe, that is correct. But as far as number one is concerned, that is believable.
We will see.
So in that eventually, at least, my lord, one protective right may be given, my lord.
We will see. Yes, next item.
Great.
Coming item,
Well, you also kindly see your last order, my lord. Okay.
19.
19, my. Petition was 19.
Oh, can it be believed that without any instruction, the deputy chief legal aid
LADC.
defense counsel will file an
Yes,
application?
they can do what I have been told. They are not required to take any consent. If they find anything, that is how. But it just,
Whether they are authorized to file a.
yes, they are for that purpose only, those persons who are in custody or other way. That is how I have been told, but I do
That
not
is,
know the
no, that
exactly
will
that.
lead to a chaotic situation.
That I do not know, I know that, but LADC, he has put his signature, it is there, my lord. Party has not put any signature anywhere.
Oh.
This petitioner, affidavit, who filed the affidavit, my lord, here. Mother has never put any signature in the bail petition filed before the trial.
Petition signed by the LADC.
LADC.
Please sit down.
Sorry.
It may be in the record, my lord, I think, that petition, my. Only question whether I had knowledge.
You saw the petition, yes, from the record.
Sorry. A flag mark, it is flag mark. I also find, my lord, how it is possible, but I have been told, my lord,
No, the system is being misused.
I do not, my, certainly it may be there. Madam. Without information or without instruction, whether they can do it, but here it is there. Madam. Logic.
Here the bail application which was out there rejected on 10 for 25 days.
No,
The
that
petition was also, my lord, released by LADC.
yes, madam. The petition which was filed there, madam. Nothing. filed by LADC. That was filed on 2/6/25. নিয়ম লাগে তোমালোকে জানা না কিন্তু কৰিব পাৰা নাই without exception. যাতে তোমরা মনে ফলো করতে পড়াশোনা করে মাগে না
So, Porthakur, have you gone through this petition?
Yes, your lordship may kindly come to page 22 also of the present petition.
22 of?
Of the petition. Page.
Page?
It is the bail rejection order dated 10/4/20.
Yeah.
So petitioner is aware about the order dated 10/4/25. That petition was also moved by the DLS, Deputy Chief Legal Aid Counsel.
Yes. But we filed here on 28/5/25.
And that order was annexed.
Yeah.
So petitioner was aware about that this petition was moved by the
No. It's subsequent bail petition. I don't know what. After that. Wow. Only question was whether the mother of the accused, whether she had knowledge or not. This is the only thing, madam. I think, madam.
Let there be an inquiry.
Yes.
Let the trial court conduct an inquiry.
That.
How this district Deputy Legal Aid Counsel has filed this application along with false affidavit that no bail petition is pending before any superior court.
That part, of course, madam, that is up to your lordship, madam, that is. But what I mean to say, madam, so far this person is concerned, he did not have knowledge. That part is different point. And your lordship raised the question whether, madam, that was done. Our question, madam, we did not have any knowledge. And from the records also, madam, your lordship may be satisfied also, my lord. But this lady who put the signature here,
okay,
or they are also saying.
You go and approach the trial court and raise the issues there.
No, trial court already, that petition already rejected. That was already this file, which was filed, my lord, on 2/6 it was filed in the court below. And 3/6 it was rejected. Because the pendency, case is pending here, man. File and it already rejected. The petition which just now.
On what ground this petition is preferred before this court?
No, this count because of Bihan Singh, madam.
Bihan Singh, you raised the issue before the trial court. Trial court, it is not a.
Then your lordship.
Trial court is not authorized to deal with the issue.
No, your lordship may, madam. I have nothing to say, madam. So that.
Heard Mr. Chaudhary, learned senior counsel assisted by Mr. M.I. Hussain, learned counsel for the accused, and also heard Mr. B. Thakur, learned additional parity for the respondent. This application under section 483 of the BNSS 2023 is prepared by accused Krishna Sil. who has been languishing in jail since 2023 in connection with session case number 27, certificate 2023, corresponding to Jugigaba PS case number 94 of 2023 under section 302 IPC, pending before the Court of Learned Additional Session Judge, certificate FTC, North Salmora, Abhayapuri, grant of bail. It is to be noted here that by order dated 19/6/2025, the learned counsel for the petitioner was directed to file an affidavit under which stating the facts under which an application
the government the SNA.
being application number 1436 of 2025 was preferred by the LADC of Abhayapuri, along with false affidavit that no bail application is pending before any superior court while the present petition is pending before this court. And accordingly, Mr. Hussain, learned counsel for the petitioner, filed an affidavit today indicating that the mother of the accused was not aware of about the pendency, about filing of the application by the LADC before the Court of Learned Additional Session Judge, Abhayapuri. Under such circumstances, this court is inclined to direct the learned additional district judge to conduct an inquiry regarding the application number 1341 of 2025 filed before him on 2/6/2025 along with the false affidavit. And the result of such inquiry shall be communicated to the registry of this court within a period of 1 week from today. Mr. Sodhuri, learned senior counsel for the accused, submits that this application is prepared on the ground that while causing arrest of the accused, the arresting authority has not communicated the ground of arrest to the accused as required, as held by the Honorable Supreme Court in the case of Bihan Kumar. Mr. Chaudhary further submits that. So, at what is this that case is pending there?
Yes, evidence stage one.
Evidence completed?
No, not yet one. Out of 15, my lord, 10 exam.
Mr. Chaudhary further submits that the said session case is pending at the stage of evidence, and out of 15 witnesses, 10 witnesses have examined so far by the learned trial court. Be that as it may, this court is inclined to dispose of this petition by granting liberty to the petitioner to approach the learned trial court again by filing an application, and on such application being filed, the learned trial court shall consider the same in accordance with law, keeping in mind the principle laid down by Honorable Supreme Court in the case of Bihan.
Please, your lordship. My lord, our matter was supposed to take, but due to respond and try to, it could not take it. My lord, I have one item. It was fixed on 2. So I may be accommodated, my lord, after vacation, my lord. Item 12. Sorry, my lord, 1990.
Which one?
I am appearing for respondent number 50.
Okay, then this court cannot take up the
Yes.
matter.
Yes.
Let's do for appropriate bench after vacation.
Yes. 19. Yes. All right.
May I please, your Lordship? Lordship, this is the third bail application, my lord. Here in this present case, my lord, altogether 3 accused persons were there, my lord.
So LCR has been received.
Yes.
Yes, LCR.
You have filed your objection? No, not necessary.
And assist from the record.
Okay, okay.
Now, my lord, here in this case, my lord, altogether 3 accused persons were there, my lord. My lord, Manish Kumar Singh, Gautam Rai, and the present petitioner, my lord, Sahib Sani. Now, my lord, Manish Kumar Singh was granted, the driver was granted bail 2 years back, my lord. Thereafter, recently, my lord, Lordship would find at page 52, my lord, page 52. My lord, I'll cut short my arguments, my lord. Because page 52, my lord, the owner was granted bail, my lord, only on 8/5/2025 by the coordinate bench of this honorable court, my lord. My lord, as on today, my lord, the present petitioner is 4 years, 6 days behind the bar, my lord. And out of 9 witnesses, my lord, this order itself reveals that only 2 witnesses have been examined out of total 9 witnesses, my lord. The lordship would find that particular aspect in the order at page 54, my lord. It starts from page 53, last para 6, my lord. Page 53, para 6. Mr. P.P. Medilani, counsel for the accused petitioner, submits that the accused petitioner has been languishing in jail for the last 3 years, 10 months and 19 days. He further submits that out of the 9 prosecution witnesses, only 2 have been examined till date. He further submits that the trial having been prolonged, the fundamental right of the accused petitioner under 21 of the Constitution is totally infringed and violated. Thereafter, my lord, the objection of the learned counsel for the NCB was also taken care of, my lord. And thereafter, my lord, the coordinate bench of this honorable court, my lord, after taking consideration of the judgments, my lord, delivered in Ravi Prakash, my lord, then, my lord, Lal Pian Wani versus State of Assam, then, my lord, Husanara Khatun versus the Home Secretary, Bihar, my lord. After considering all such judgments, my lord, this honorable coordinate bench of the honorable court was pleased to allow the owner of the vehicle, because, my lord, altogether 3 persons are there. Myself, the handyman of the vehicle, my lord. The owner and the driver has already been released, my lord. Now it is the handyman who has been languishing in jail, my lord. So,
Driver has been released.
Yes, driver has been released, my lord, 2
By
years
order
back.
dated?
My lord, the driver was long back 2 years back, my lord. The exact date I am not having, but that is there in the record, my lord.
Where is that order?
The driver been granted bail, my lord. That order I am not having, but that order is there in the record itself, my lord. It was granted by the trial court itself, my lord. The driver. And now, my lord,
On
recently
what
the
ground he was enlarged on bail?
my lord, the driver, my lord, he was, since he was unwell and he was having some medical conditions, my lord, for that, my lord, he was granted.
Medical ground.
Yes, my lord, 2 years back. But as far as the owner of the vehicle is concerned, who was there inside the vehicle, my lord, it is not the case that the owner who has been granted bail by the coordinate bench of this honorable court was not inside the vehicle, my lord. He was also inside the vehicle, my lord. So all 3 were, my lord, intercepted, my lord, at Baihata Charali, and thereafter, my lord, in this captivity of the vehicle, my lord, behind the driver's seat, my lord, 236.29 kg of ganja was seized, my lord.
So this is the second application or
No,
third?
third application, my lord.
Third application.
Yes, my lord.
What is the ground for preparing this third application?
My lord, on the ground of parity.
On the ground of?
Parity.
Parity.
Parity. Parity in the sense, my lord, why I am saying.
In bail application, parity is applicable.
Yes, my lord, it will, because, my lord, the recent Supreme Court judgment I am placing, my lord, wherein, my lord, justice, it was, my lord, 3-judge bench of the Honorable Supreme Court, my lord, reported in Suraj Vijay Agarwal versus State of Maharashtra, my lord. My lord Justice, the present Chief Justice of India, my lord, B.R. Gavi, City, Ravi Kumar and Sanjay Kumar observed that since the Honorable Court has granted bail to the other co-accused, so the present petitioner also deserves the bail on the ground of parity. Because, my lord, why I am saying so is, my lord, otherwise parity is a law which is taken note of by the Honorable Court. We can only submit that since the other co-accused persons are released, my lord. But it is the Honorable Court who, at the time of passing the order, your lordship considered the law parity, my lord.
Mr. Tiwari,
Yes,
whether
lord.
the law of parity is discussed in this,
No, in this case,
this,
it was
in
otherwise
application?
not. It was not otherwise discussed in this case.
Then,
My lord, the judgments of P. Chidambaram, my lord, Harmit Kumar is clear on the face that, my lord, once the other co-accused persons are granted bail on similar terms and conditions, my lord, the co-accused should not be denied the bail, my lord. That is what the concept is. Here, my lord, the concept of, my lord, whatever submission my learned brother colleague for the NCB has made, my lord, the very same submission he has made, because the order which the coordinate bench of this Honorable Court has granted bail, my lord, would kindly see, my lord, the submissions which he has advanced. He has taken everything, my lord, but the court has considered that. But having been in that position, my lord.
Mr. Tiwari, his application has to be decided on its own merit.
That's correct, my lord. That's correct, my lord. But my lord, the aspect remains is that if otherwise also this judgment, my lord, if the coordinate order, my lord, the bench of the order of the coordinate bench, my lord, there itself, my lord, all the aspects of Article 21 and other aspects were taken consider of, my lord. If your lordship allows me, I'll read out the relevant
No,
paragraphs.
not necessary, not necessary.
So, my lord, in my humble view, my lord,
That's
since
well said.
other two accused persons have been granted bail, my lord. So, my lord, and that apart, my lord, 4 years, 6 days, my lord, 4 years, my lord. It is not the case that, my lord, even if I'm there behind the bars, my lord, I am entitled, at least I'm entitled to a speedy trial, my lord. Tomorrow, my lord, I'm convicted and I'm behind the bars. That is a different aspect, my lord. But Article 21 also allows me to have a speedy trial, my lord. My lord, I have been erected, my lord, on 18/6/2021, my lord. And now, my lord, it is 25/6/2021.
When the charge was framed?
Charge was framed on, my lord, 23/12/2021.
21.
Yes, my lord, 23/12/2021.
So who is responsible for the delay?
My lord, it is the NCB, my lord. They should have produced the witnesses, my lord.
Charge was framed on
23/12/2021.
How many witnesses have been cited in the final report?
9 witnesses, my lord, altogether.
And how many witnesses examined?
2 examined, my lord.
3 lord.
3. I don't think so, my lord, because I could not find the third deposition on the record, my lord. On the record, I could not find the third deposition, my lord.
16/6/2025. PW3 was examined and he was cross-examined on 18/6.
My lord, that I could not find in the records, my lord. I have not found that part in the records, my lord.
It is available in the record.
If that is so also, my lord, till, my lord, 6 witnesses are remaining, my lord. Even that is the position, my lord. For 3 witnesses, my lord, they have altogether taken, my lord, 4 years, my lord.
So your main ground is parity.
Parity. And rest I leave it to your lordship because, my lord, under Article 21 also, my lord, I am entitled to, my lord, speedy trial, my lord. And for indefinite period, I cannot be put behind the bars, my lord. At some point, my lord, I'm entitled to, my lord, some relief, my lord. And my lord has seen, my lord, the
Mr.
progress of the
Kailo,
trial.
why the case is pending
Lordship, here in this case,
stage of evidence?
there was some delay that is admitted fact. Lordship, the learned trial court, at the instance of the NCB, Lordship are now examining the witnesses online. The last witness was examined on 18/6/2025. His cross was completed on that day. It was started on 16. On 16, Lordship, counsel for the accused was not available.
When examined?
18/6/2025.
18/6.
And his course was completed on 18/6. And next date is fixed on 2/7. 2nd of July. My landed seeking bail on ground of parity. I've submitted one judgment of Honorable Supreme Court. It is judgment. Paragraph 11, Lordship, it is case.
Go ahead.
I've given the copy, Lord. 2022 Supreme SC page 56. Paragraph 11. Earlier, also Lordship was to consider it. However, in the evidence brought before the us against Muhammad Abdul, accused 2, respondent in SLP number so-and-so, subject matter of the second, that is NCB case number so-and-so, who was granted bail by court so-and-so, will have to be treated on an entirely different footing. There are specific allegations leveled against the said respondent regarding recovery of substantial commercial quantity of drugs from a rented accommodation occupied by him, pursuant to which he was arrested on 16 June 2019. This aspect has been completely overlooked while passing the order dated so-and-so, wherein only reason for the appears to have been repeatedly the High Court raising him on bail is that his case stand on the same footing of accused A1, A3, and A4, who have been enacted in by order dated so-and-so. In connection with the second case, the Registrar of the Department, we are of the firm view that accused A2 cannot seek parity with the aforesaid co-accused. No such benefit could have been extended to him in view of section 37 of the Act, when he was found to be in conscious possession of the commercial quantity of psychoactive substance as contemplated under NDPS Act. Lordship here. Lordship may come to page 43 of the bail application. Page 43 of the bail application. Paragraph 43 on what? See the role of accused Sahib Sani. 43. The seized 236 kgs of ganja recovered from the conscious position of Sahib Sani and 2 other accused persons from third number 20. The statement given by Sahib Sani that he was involved in trafficking of ganja for monetary benefit and he was directed by so-and-so to load the ganja at Senapati district of Manipur. That is the statement given by Sani that he was being paid rupees 20,000 by Sumit Singh, receiver of the ganja, for carrying the said ganja from Senapati district Manipur to Manipur, Bihar. The packet of ganja was recovered from truck number so-and-so from the position of Sahib Sani and his position and in presence of independent witness, namely Sri Hitesh Bushu. That 23 packets of ganja were recovered from truck number so-and-so from the position of Sahib Sani and in presence of independent witness, namely Vijit Mandal. Then paragraph 58. The Sahib Sani was in treatment mobile phone number. It is associated bottom type on analyzing CRD so-and-so, which was used by Sahib Sani with the following conversation so-and-so. So, sufficient metal is there. Section 37 will come into play as held by your lordship in different judgments. I have one copy of that.
Only to counter this part, my lord, I am placing the Ravi Prakash judgment, my lord. Ravi Prakash judgment, authored by my lord Justice Surya Kant, my lord, and my lord Justice Dipankar Datta in Supreme Court, para 4, my lord. Para 4, my lord. In the first page, my lord, para 4 is there. As regards to the twin condition contained in section 37 of the NDPS Act, learned counsel for the respondent state has been duly heard. Thus, the first condition stands complied with. So far as the second condition, reformation of opinion as to whether there are reasonable grounds to believe that a petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years in custody. The prolonged incarceration generally mitigates against the most precious fundamental rights granted under Article 21 of the Constitution. And in such a situation, the conditional liberty must override the statutory embargo created under section 37 1B2 of the NDPS. So that part has been taken care of. Well, I'm 4 years, 6 days behind the bar, madam.
This judgment is of 2 judgments.
Yes, madam.
And the other judgments referred by Mr. Kyle is of 3 judgments.
My lord, there are other judgments. If your lordship grants me one more day, my lord, then I'll place my lord, the other judgments also, my lord, which says that ki parity is there, my lord. I'll show 5 judges bench also judgments where it says that ki if the other co-accused persons are, because my lord, law of parity is only on the court. The court takes the law of parity, my lord. It is not that ki as a matter of right, we will place that, my lord. Because after your lordship passes some orders, my lord, we take that as a ground to show that since similar accused, but the law of parity generally is taken, the law is taken by the courts only, my lord. It is not for the.
No, Mr. Tiwari,
Yes,
you
madam.
see from the final report, the allegation against you.
My lord, the allegation against the other two are
whether
also
you
same. my
were,
lord.
you were stands in the same footing with that of the other two accused.
Correct, my lord. I'm
Oh.
standing on the same.
You have received 20,000 rupees.
My lord, that is their only allegation which is not been found by a trial, my lord. The trial, had they could have taken the
Whether
trial
trial
to
is
the final
over?
conclusion, my lord, it is only a statement which they are saying so, my lord.
No, whether trial is over.
No, my, that is what I'm, my lord, that is why, my lord, I'm invoking Article
Whether
27 of the
he is
Constitution.
entitled to establish the allegation before the trial court.
My lord, that they need to, because till date, my lord, those are the
Anyway,
documents,
you
prosecution
produce,
documents
you
only, my lord.
produce the decision in respect of parity. We'll see.
My lord, I'll place that, my lord. I'll place those judgments, my lord, parity, my lord.
So Tiwari, your name is also not there in the
My lord, I'm extremely sorry, my lord. My lord. In the earlier application I was there, I have argued also, my lord. But since, my lord, I was not in stations on the day of the filing, so could not be. My lord, Mr. Tapan was
if
left
tomorrow
for the.
somebody complains about it, then we
That,
have
my lord,
no.
extremely sorry, my lord. I'll make the signatures by tomorrow, my lord. That's it, my lord.
But Mr. Tiwari, learned counsel for the accused, and Mr. S.C. Kaya, learned standing counsel for the NCV. Heard in part, list the matter. When Thursday?
My lord. No, my lord, after vacation, it will be too long, my lord. Only 2 judgments I'll place, my lord.
Not for hearing, only for production of judgment.
Only for production judgment. I'm deeply obliged, your lordship, for giving a patient hearing, my lord. May I please, your lord? Well, this is a civil revision petition. I have come against an order of dismissal of my 711 application, but a learned trial court. My 711 application was filed on the ground that the suit is barred by law of limitation. And if on a meaningful reading of the plaint, it is clear to the court that the suit is barred by any law of the land, it has to be rejected at the threshold. There are now catena of judgments of the Honorable Supreme Court where they say that if any plaint which is clearly manifested in the plaint, in the meaningful reading, that the suit is barred by law, then this has to be rejected. There's no point prolonging the litigation, because eventually this is going to be dismissed. Now, Lordship, may kindly turn to page 27, which is the plaint. And since I am challenging the plaint, I need to read it. Lordship, may kindly bear with me. Page 27, my lord.
Yes.
Yes. Lordship will see the heading of the title of the matter. Suit for declaration, confirmation of title, partition with separate possession, and for permanent injunction. So this is basically a suit for declaration. Though they seek partition also, this is a suit for declaration for all intents and purposes. Now, it may not be advisable to read the entire plaint, but then still it is necessary that I take my lord through the plaint.
No. You come to the relevant portion of it.
Because I have to give a brief background also, my lord. Or else I can come to certain paras of the plaint, which I am challenging. Before that, my lord may kindly turn to page.
Let us do one thing. First, let us see the impugn order.
Yes.
At page number?
Yes, 113. 1 on 4.
Yes.
May I read it, my lord? With the
Yes.
following order, this miscellaneous so-and-so case will be disposed of. Petitioners Hardeep Singh Matharu, Sardar Amarpal Singh Matharu, and Sardar Kamaldeep Singh Matharu. I am the defendants. Filed the petition number so-and-so under Order 7, Rule 11D, CPC, with a prayer to reject the plaint showing cause. It is contended that the said three petitioners are implicated as defendants number so-and-so in title suit number so-and-so, which suit was filed by opposite parties as plaintiff number 1 to 3 for declaration, confirmation of title, partition with separate possession, and permanent injunction. The opposite parties are claiming 1/5 share in the properties of late Tahil Singh, died on 1/11/1955, and late Dhan Kaur, died on 20/12/71, as heirs of late Balwan Kaur, who died on 7/9/72, who was one of the 5 heirs of late Tahil Singh and late Dhan Kaur. So I, being the defendant, with the rest of the defendants, I am also legal heirs of late Tahil Singh. It is contended that Balwan Kaur was not entitled to any share in the properties of late Tahil Singh, who died on 8/11/1955, as the Hindu Succession Act came into force on and from 17/6/1956. It is contended that the claim of partition so made in title suit number so-and-so is barred by law of limitation as provided in the subclause B of explanation to Article 65 of the Limitation Act 1963, and the possession of the petitioners, that is defendant number 2 to 4, has become adverse in view of the death of Dhan Kaur on 20/12/71, for which the plaintiff is liable to be rejected. In fact, there were a number of other arguments also which the learned judge does not take note of. I'll come to that later, Mala. Opposite parties file written objection contending that the petition is not maintainable. It is contended that prior to enactment of the Hindu Succession Act, there are several other statutory laws as well as judicial pronouncement of the apex court under which daughters are entitled to the properties of the parents. It is contended that the opposite parties, along with written statement, have filed a copy of registered deed of partition and deed of gift bearing number so-and-so, dated 33/1970, as well as a copy of registered deed of disclaimer bearing number so-and-so, dated 23/9/1972, which document should go on to show that petitioners themselves acknowledge their legal rights of late Balwan Kaur in respect of the immovable properties left by her predecessors. It is contended that the petitioner cannot claim the plea of adverse possession either on facts or under the provision of law. Opposite parties prayed for rejection of the petition. Perusia courteously heard elaborate submission made by both the learned counsel for the parties. Learned counsel for the petitioners submitted that as the suit is hopelessly barred by law of limitation, hence the plaintiff is liable to be rejected. Par contra, learned counsel for the opposite parties would submit while relying on a decision as reported in 2022 Life Law SC 963 that while deciding an application under Order 7 Rule 11 CPC, the court is only to consider the averments made in the plaint and not the strength and weaknesses of the plaintiff's case. The plaintiff's suit is primarily for declaration and permanent injunction. My lord, may kindly note this. Plain reveals that the opposite parties as plaintiffs have sought a decree for confirmation of right, title, and interest of plaintiffs and performer defendant number 9 to the extent of 1/5 share in each and every dag of the suit patta as described in Schedule A to the plaint. As far as the rejection of plaint is concerned, the sustainability as such has to be decided on the averments made in the plaint, and one has to treat every averment in the plaint as factually true, which is not always correct. There are a number of judgments to this effect. So far, the suit being barred by law of limitation is concerned, limitation itself is a mixed question of fact and law, and the questions involving a mixed question of law and fact may require not only examination of the plaint but also other evidence. But the said question cannot be determined at this stage. This is also wrong. Hence, it cannot be held as of now that the suit is barred by law of limitation. The contents of the plaint in the present suit have been scrutinized on its face value, and it is prima facie found that the lease is not barred by any law of the land. Needless to add, the plaintiff is not liable to be rejected under order so and so.
So where is your petition?
Pardon,
Where is your petition?
Yes, It's at page 65 to 87. Kindly turn to page 65. This is annexure 3. Manoj got it?
Yes.
May I read it? That the opposite parties number 1, 2, and 3 have filed title suit so and so in this court for declaration, confirmation of title, partition with separate possession, and for permanent injunction against these 3 petitioners, pleaded originally as defendant number so and so. The opposite party number 4, who has been, that part I can leave, I think. This is not necessary. Can it come to page para number 2, my lord? That all the opposite parties are claiming 1/5 share in the properties of late Tahil Singh and late Dhan Kaur. The said opposite parties together claimed a share in the properties as heirs of late Balwan Kaur, who was one of the 5 heirs of late Tahil Singh and late Dhan Kaur. That late Tahil Singh died on 8/11/1955 and late Dhan Kaur died on 20/12/1971. Late Balwan Kaur died on 7/9/1972. Balwan Kaur is their mother. That in the properties of late Tahil Singh, who died on 8/11/1955, Balwan Kaur was not entitled to any share as the Hindu Succession Act came into force on and from 17/6/1956. The claims of partition having been made in title suit number so and so, filed on 6/4/2016 in this court is barred by law of limitation as contained in sub-clause B of explanation to Article 65 of the Limitation Act 1963. The position of these defendants petitioners has become adverse in view of death of Dhan Kaur on 20/12/1971. That the petition number to Amarpal Singh Mathur dependent, that is also not required. That in view of the above said provisions of law, the plain so and so is liable to be rejected. Now, my lord, may kindly turn to the prayers prayed for in the plain, which is at page 35, my lord.
Page 30?
35, 35. Yes. Relief number 1. Declaring that any alleged partition deed may have been executed by the defendants without the consent of the plaintiffs and pro forma defendant number 9 or their mother is void ab initio and subsequent / alienation mutation on the strength of such deed is void and liable to be cancelled. This is what the declaration they are seeking, and also 1/5 share as per their claim. Now, my lord would kindly note that what they have stated here, declaring that any alleged partition deed. Now, what is that deed? They do not name it. They do not give the date of the deed. Totally silent. Now, how can a court declare a deed or for that matter any instrument without knowing what is the date, which is the deed? Are they expecting the court to do an inquiry? Now, I will come to the reason why they have not mentioned the deed, which is the gist of the matter. Now, come to prayer number 2. Decree for confirmation of right, title, and interest of the plaintiffs and pro forma defendant number 9 to the extent of 1/5 share in each and every dugs of the said patta land so and so. And how have they sought this confirmation of right or declaration that they are entitled to 1/5 share? Is that their mother, Balwan Kaur, was entitled to 1/5 share in the properties of her parents. So the plaintiffs here are seeking 1/5 share through their mother of their grandparents' properties. Now, kindly turn to page, para number 16 of the plain. Para 17, I'm sorry. Para 17. That cause of action for this suit arose at Jorhat within the jurisdiction of this court on and from 7/8/1972. That is, when the mother of the plaintiff and pro forma defendant number 9, late Balwan Kaur, died. Kindly note the date, my lord. 72, she passed away, and they filed a suit in 2016. Even assuming they had any rights, they never exercised that right. Now I'll come to the plain a while later. After that, what they say, just to make the cause of action alive, they go on to say that on and from 18th of August 2014 and date prior to that, nobody knows what is that prior date. When the plaintiff number 4 entered into negotiation with defendant number 4 for mutual settlement and partition of the suit property on and from 19/12/2014, that is date when the plaintiffs and former defendant number 1 to 4 through their lawyers so and so by registered post AD on and from 22/12/2014, that is the date when the defendant number 1 to 4 duly received the plaintiff's notice from the lawyer of the plaintiff and on from each and every date thereafter. So this is not a matter under Negotiable Instrument Act that legal notice gives you cause of action. Then, my lord, page para 31, my lord, the plaint. Not para 31, page 31. Page 31, my lord. I'll link this with the prayer number 1. Why the prayer number 1 is most frivolous. Para number 11, they say that properties in the suit for declaration, confirmation of title, partition, separate possession, etc., are covered by various periodic pattas. Now, at the bottom, they say some of the properties originally acquired by the predecessor common ancestors of the plaintiff and the defendants were illegally sold, transferred, gifted by the defendant number 1 to 4 to various persons, which included their family members. Now, kindly come to the next para, my lord. Para number 12. This is very crucial. Here they say that some of the orders in the certified copy of the Jamabandis issued by the concerned revenue authorities, it has come to light that the defendants taking pretext of an alleged deed of family partition and gift have unilaterally gifted, transferred various lands from out of the estate by late Tahel Singh and late Dhan Kaur to the family members and exchange between the defendant number 1 to 4 and their successors. Moreover, the defendant number 1 to 4 as well as their other family members have transferred some valuable properties by way of sale / gift, etc. to some outsider. The deed of partition and of gift, if any, executed by the defendants are also void ab initio because of the fact that they cannot execute any such deed or documents without the express consent of the plaintiffs and proper defendant number so or their mother, Balwan Kaur Tichi. Now, this is their case that they are entitled to 1/5 share, and they are alleging that we, the defendants, are in possession, and by virtue of a partition deed, we are disposing of the properties as per our wish and whims. Now, kindly come to para 12 once again, the initial part. That some of the orders in the certified copy of Jamabandis issued by the concerned revenue authorities, it has come to light that defendants taking pretext of alleged deed of partition, family partition, and gift. Now they take out Jamabandis. They go to the concerned revenue authorities or whoever. Did they not check the particular deed, the partition deed? They are well aware of the fact that there was a certain partition deed, and because the partition deed was executed many years ago, they cannot possibly give the date of the partition date. Because as per Article 59 of the Limitation Act, if you are seeking cancellation of a deed, registered deed, then limitation is 3 years. You cannot go beyond 3 years. They do not even clearly say the date of knowledge. Supreme Court repeatedly says that date of knowledge at least should be mentioned in the plaint. They are totally silent on that. If they mention the particular year of the deed in their relief prayer number 1, they cannot stand even for a minute. I'll highlight a few more. Now, para 7, my lord. I will not take much time. I will be very brief. This is at page 29. Para 7. That the plaintiffs are negotiating with a said defendant number so and so for quite a long time. Now they don't say when, since when. This is also very vague. They have no choice but to state such things because they otherwise limitation is hanging over their head. Now then they talk about some meeting on 18th August 2014 at Jorhat. Now, again to page 35, Muller, relief number 2. Decree of confirmation of right, title, and interest of the plaintiff, so that they are declared entitled to 1/5 share. Now, how are they claiming, as I have submitted a while ago, that they are claiming this 1/5 share through their mother, late Balwan Kaur. Now, they do not deny my position. They, in fact, very clearly state in the plain that I am also one of the legal heirs. I mean all the defendants. So what they want today is that they want 1/5 share. Now, since they do not deny my possession, Article 65B comes into picture. My lord, may kindly have a look at Article 65B of the Limitation Act.
Article
65B.
Yeah.
Read it, Bala? For possession of immovable property or any interest therein based on title. Now, B applies in our case. Where the suit is by Hindu or Muslim entitled to the possession of immovable property on the death of a Hindu or Muslim female, the possession of the defendant shall be deemed to become adverse only when the female dies. So this is 12 years. And their mother, Balwan Kaur, died way back in 1972. And here, through whom they are seeking their right? Through a female. That is their mother. And she died in 1972. Suit came to be filed in 2016. Now, yes, ma'am. Therefore, my lord, the suit is hopelessly barred by law of limitation, and I respectfully disagree with the order of the Learned Trial Court, the impugn order. Law of limitation is not always a mixed question of law and fact. If it is clear on a plain reading, plain in the sense it has to be a meaningful reading, as has been urged by Supreme Court, and they have Supreme Court repeatedly urged the trial court that a meaningful reading of the plain is required. And if on a reading of that, if it is found that the suit is barred by law, then it has to be dismissed at the threshold. Now, I would like to cite a couple of judgments, my lord. I will read only the relevant paras, hardly 2-3 minutes.
Which paragraph you have relied upon?
My lord, the third page, it is 550 here.
Paragraph number.
Yes. It is, citation is this. 2005, 580. Paragraph number is H, my lord. Z and H. Lordship, may I kindly have a look at page Z, para Z. At the bottom. In this particular case, what had happened was that the cause of action for seeking such a declaration and for obtaining reconveyance deed, according to the plaintiff's own averments in para 9 of the plain, arose on 25/3/1987. When the plaintiffs claimed to have paid back the entire loan amount, etc., the suit filed on 26/8/1996 was hopelessly barred by time. In our case, as per their own para number 17, cause of action arose on 1972. And as I have submitted, it cannot be a continuous cause of action. And even if it is continuous cause of action for a moment, we say, then also right to file the suit arose to them when it arose for the first time. The cause of action arose accrued to them for the first time. That is 1972. And they say 1972, they all were minors. It's not that they were not born in 1972. 1990, if they were alive in 1972, they would have become major in 1990. In fact, in this, there was a cost of 10,000 imposed on the petitioner for dragging the matter to the Supreme Court, which according to the Supreme Court is a hopeless case. Lordship may lead the head note. This is a salutary judgment. Raghavendra Saran Singh, Ram Prasanna Singh.
No, head note will not do. You come to the relevant paragraph.
Yes, I'm coming to that only, my lord.
Which is the relevant paragraph here.
Relevant paragraph, my lord. Page B, para number B. So far as the application on behalf of the original plaintiff and even the observations made by the trial court, as well as the High Court, that the question with respect to the limitation is a mixed question of law and facts, which can be decided only after the parties lead the evidence, is concerned, as observed and held by the Supreme Court in Samlal.
This paragraph number of this judgment.
Yeah, this is B, para B.
B is not paragraph. Paragraph number is
This is the head note.
numerical.
Yes. Because I'm avoiding going to the bottom of the case. This is, I'll find it out.
Okay, then I will try to find it out. Yes.
I have one more to move that. Same on the same footing.
No, not necessary to multiply the decision.
Yes, fine.
Yes.
Please. Before going to the merit of the matter, I would like to draw your honor's attention to the very provision of law, that is Order 7, Rule 11, for rejection of plaint. Plaint shall be rejected in the following cases, where it does not disclose a cause of action. That is one. Now we have causes of action we have given. Where the relief claimed is undervalued, is not our matter. C, whether relief claimed is properly valued, but the plain written, this is also not the within the case. D, where the suit appears from the statement of in the plaint to be barred by any law. So that is, your lordship has to adjudicate whether it is barred by any law. Now, now from the bare perusal of the Order 7, Rule 11, it is clear that while deciding a petition for under Order 7, Rule 11, your lordship, the court has to see the plaint and the plaint only. The arguments given by them, and in this regard, I would like to draw your lordship attention to page number 6 of the petition, the instant petition filed by the petition. That para 5 that the petitioner defendants beg to state that bare perusal of para 17 of the plaint would show that the respondent plaintiffs have sought to create an illusory cause of action to the 1/5 share of both of their maternal grandparents' estates based on the date of their mother Balwan Kaur on 7/9/72. Now, whether my cause of action is illusory or otherwise, it can only be decided by a trial. Now, provision of Order 7, Rule 11 does not give that there should be illusory cause of action cannot be given. Whatever. I'm not admitting the facts, but what that is, I'm stating there on the context of the petition. So, my plaint discloses cause of action. Whether it is illusory or otherwise, that can only be decided by a trial. Your at this threshold, court cannot consider the genuinity of my cause of action. Now, para 6, the petitioner defendant beg to state that respondent plaintiffs in the plaint suppressed the date of Sahel Singh, their maternal grandfather, on 8/11/55.
Which petition you were reading?
I'm reading the
revision
petition itself.
Okay.
Yes. Para 6, page number 6, para 6. I have earlier read para 5. That the petitioner defendants begs to state that the respondent plaintiff has suppressed the date of Sahel Singh, their maternal grandfather, on 8/11/55, which was when the succession opened, to create an illusory right to the shares of the assets, which they claim in para 7 of the plaint, accrued to them so and so, so and so. Nowhere do they state in the plaint or in the genealogy file along with it, the undisputed fact that the Sahel Singh died over 6 decades before filing of the suit. It is also an undisputed fact that case all the. Now, whether I have suppressed material facts or not, that is also cannot come under the purview of at least Order 7, Rule 11. Whether I have suppressed material facts or not, without a trial, court cannot decide. And that is also, we have a very, under Order 7, Rule 11, your lordship, we have a very limited scope. Because court has to deal on the plaint, averments on the plaint, not the strength and weaknesses of the plaint or the averments made in the written statement. Written statement cannot be.
No, that is well settled.
That is well settled. So, para 7.
No,
Page 8.
The counsel for the petitioner mainly relied upon this limitation.
Limitation. Regarding limitation, I'm coming
to that point directly.
Yeah, I'm just coming to the limitation. Lordship. Now, in a partition suit, that too of a joint family, the ownership of the other joint owners, that means my other brothers, is prima facie considered to be my possession. The possession of my other co-owners is prima facie considered to be my possession. You know, I have 5 brothers and I am living somewhere else. I am not possessing physically. The possession of my other brothers is considered to be my possession. That is the settled law. You know. So because, and regarding the point of limitation, I would like to draw your lordship's attention to a judgment passed by the Honorable Delhi High Court, 2017 SCC, online Delhi 9060. Your lordship may kindly see para number 10. Para number 10 of the. I'm just reading out the relevant para. The law of limitation does per se not prescribe any fixed time for period for filing suit for partition in a case of joint family property or joint owned properties. Joint family properties purchased in joint names are inherited can continue till partition is sought. Law does not prescribe any fixed time period in which a suit for partition must be filed by one joint owner against the other. Now, I have a joint property. This is being joined. There is no limitation for filing a suit for partition. I did not desire that it should be partitioned, and now after 50 years or 100 years I can come. There is no fixed period for filing a suit for partition. You know. That can remain, and this judgment is very clear regarding filing of a suit for partition, and the limitation act does not apply. Now, regarding cause of action, I have already stated my cause of action is causes of action, a series of events here. So now another point my learned friend is harping that in the context of my plane that I have inquired, I have come to know regarding a partition deed by observing the Jamabandi. Now his another argument is that I could have seen the partition deed from them. You know, in a Jamabandi, partition deeds are not enclosed. That's why I am saying allegedly. In the order, I could find that they have partitioned the property, they have sold the property, or they have divided among themselves the property by way of a partition that was there in the Jamabandi. That is a matter of trial. Now, whether I have not disclosed the partition deed, I have not mentioned about the date of the partition deed is irrelevant, at least at this stage. This is a matter of trial. So, plaintiff have not denied my possession. As far as the possession is concerned, which my learned friend has submitted, possession I have already submitted. It is a settled law that my possession, my brother's possession is my possession. So, merely because I have filed a suit beyond 12 years, suit for partition beyond 12 years does not ipso facto bar me. There is no provision of law that it is barred by law that I can file a suit for partition beyond 12 years. So in this regard, I have already filed the Honorable Delhi High Court judgment. And regarding whether the limitation is a mixed question of law and facts, is there a plethora of judgments. I am citing one judgment of Honorable Supreme Court 2022-1
Supreme Court cases 572. In the very footnote, Civil Procedural Order 7, Rule 11, Order 14, Rule Order 37, rejection of plain ground of limitation when facts surrounding issues of limitations are disputed. Held in such circumstances, the issue of limitation cannot be decided as preliminary issue. Now coming to para, next page, Your Honor, next page. Whether appellant set up plaintiff into proof would depend upon the evidence adduced by trial, course of action which was followed by a trial court of directing parties to address arguments on issues of limitation was irregular. Issue of limitation in present case held would require evidence to be adduced. Determination of issue of limitation in present case is not a pure question of law, hence held cannot be decided as a preliminary issue. There are number of similar judgments from our own High Court as well, Your Honor. I will not like to take much of your honor's time by reducing those in the recent judgment. In another judgment, 2018 Supreme Court case 422. In this suit, first page of the judgment, next second para. In this suit, defendant number 5 filing an application under Order 7, Rule 11D CPC for rejection of plain on the ground that suit is barred by limitation, having been filed after 17 years of execution of cell deed in question, considering totality of the averments in the plain held, which of articles against Article 56 and so 65 and other articles limitation will apply in the present case was to be considered at the appropriate stage. Thus, issue regarding suit being barred by limitation was triable issue in fact situation of the present case. Consequently, plain could not be rejected and threshold in the exercise of power under Order 7, Rule 11 DCPC is a affirming decision of trial court. So, the sum and substance of the judgment is very clear on that lordship that limitation is a mixed question of law and facts, and which has been rightly observed by the in order by the learned civil judge Jorhat. Now, so I support the judgment, and at least this case at this stage, this is not a fit case under to be rejected.
But you were not disputing that Mother Balawan Kaur died on 7/9/1972.
Yes. Your Honor, my as my mother died, that is admitted, Your Honor. But they are claiming that as I have filed this suit lately for partition.
No, I said declaration.
For partition and declaration of the Your Honor, declaration partition are the combined plea on. Now, as soon as my mother died, I automatically stepped into my shoes of mother, and the share of my I have automatically inherited the share of my mother. So the cause of action is a continuous process. So I have not, when my mother inherited a share from my grandfather Tahel Singh and Balwa and Hanpur. Hanpur died in 1972, and my mother 71. So regarding the judgments cited by my learned friend is not relevant in this particular case. That is my submission, which my learned friend has submitted. So the petition filed by the petitioner is liable to be rejected. And regarding adverse possession cannot be decided merely at a threshold here. Adverse possession is a very, and regarding adverse possession of claimed by the OCR of the own brothers, it is very tough. At a threshold, it cannot be decided.
May I rebut for a minute, Mullah? Regarding his contention that you do not get the date of any deed in a Jamabandi, it cannot be accepted. If you have gone to take out a Jamabandi from the same office, it is but obvious that you got to know about the deed also. This is no argument. You go to a particular office to take out Jamabandis, and there you, as per your own averment, that on the basis of some deed, I have been alienating the properties. Now, how come you do not know the date of the deed?
Lordship, this is
Lord, can I,
purely of trial, Your Honor. Whether I am aware of the fact or not is a purely matter of trial. If it would have been a suit for final appeal,
Otherwise, there would have been no provision for 711. This is what the judgments say. It's clear on the face of the record, face of the plain. Lord, can I give few more judgments before the order is passed on the same night? Very short judgment, Lord. I'm obliged. Deeply obliged.
Okay. Pardon, sir. Good night.
Atanu Saikia.
Pardon?
Atanu Saikia.
Don't say, yeah, learn it for the Mr.
Ronaldo Bordoloi.
M. Bordoloi.
MJ Bordoloi.
MJ Bordoloi, learn it for argument concluded. Order is adjourned.
Obliged.
Number 23.
May I please, Your Lordship? My senior is not well, so senior is not well. So kindly urgent the matter for.
Okay. As agreed by learned advocates of both the parties, let's say, shall list the matter. Okay. After vacation. Take it that from me.
Hello.
24 and 25.
May I please, Your Lordship? Lordship, on the last occasion, Your Lordship had directed the appellants, because here I am on a petition filed by me with regard to violation. And on the last occasion, if Your Lordship, they had informed that one of the appellant had expired, and Your Lordship had asked for an information from them. And it has been confirmed by Mr. Shom that appellant number 2 has in fact expired. But in spite of that, the other legal heirs of appellant number 2 is already on record. So that should not hamper the process. And moreover, in a violation, Your Lordship, it is a case of quasi-criminal jurisprudence is applied. So once one of the violator dies, his legal heirs cannot be brought into that for the value, though his 2 sons are already on record.
Mr. Sohan, you were appearing for the respondent. So what is your instruction regarding the paragraph furnace on?
Actually, there is allegation of my lord. I think my lord, let the point my lord to this.
Information.
In written, whatever allegation is there, then I shall file it.
No,
That is already over because this is a case after the evidence has been recorded, it has been sent out here, the miss case. Your lordship may take up IA 2546. On the basis of an order passed in IA 2546, the learned trial court was directed to record the evidence. And thereafter, the records have been transmitted back to this honorable court for hearing upon the IA 2546.
Mr. Chauhan, you have received the copy of this application?
Quantum Mellon. Quantum petition.
2546,
No,
they
it is
appeared, Your Lordship.
order 39, rule 2 ACPC.
Yes, they appeared and they haven't participated in the cross-examination of the witness out there.
Then why another petition is required to be filed by him?
That is what I'm saying.
The allegation that recently.
But that is a different thing, what I had placed on record with pictures that even after the violation order was violated.
Then, my lord, it will require hearing.
Yes, we are today before the hearing.
Let my, what is the?
You want to file a written objection or reply? Yeah.
No, it is recorded in the court below. Evidence recorded in the court below. And it's transmitted here, here. So on that basis, here we taken place. Because what is the injunction order? The nature and character of the complaint shall not be changed by any of the party. This is the order. This is order dated 9/6/23. So, my lord, then my lord argued that this the plan had changed the nature and character of the plan. Let them argue. I shall try.
Your Lordship, for that purpose, Your Lordship will have to take up the application which we filed with regard to the violation and the three evidence we led before the trial court and which with the three witnesses were cross-examined. Now, if Your Lordship takes up IA 2546, that is the application of violation. Now, here we had specifically stated in para 2 that the subsequent to the passing of the order of 9/6/23 by this honorable court, para 2 of this particular application, 2546, page 6, that subsequent to the passing of this order of 9/6/23 in presence of both the counsel, the respondents have been carrying out numerous activities, and in that application we have annexed the Ajahar as well as some photographs with regard to the violation. The dates of the Ajahar are 14/6/23, 25/7/23, 25/7, 29/7/23, and some photographs we had annexed. Now, Your Lordship will find those photographs, etc. is there, and the Azahars which we had filed are annexed with this application, Your Lordship, as Annexure B, etc. Annexure B and C at page 18. Here, what they have done, that they have been carrying out construction activities and as cultivation over the suitland. Against this honorable court directed for taking of evidence, we had filed three evidences, PW 1, 2, and 3. I think the transmission of the records are there, Your Lordship. Evidence on affidavit of PW 1, Samir Ali. If Your Lordship takes up from the records that has been transmitted.
Okay.
Hedina flag lagai disu.
Yes.
If I may read out, because what has happened is during the cross-examination, some vital statements which we have raised through our evidence, no cross-examination was done on those points. For that purpose, I need to take Your Lordship to the statements in the evidence here and the cross-examination. First is the evidence of Samar Ali, PW1. If I may read out here. That I'll skip para 1 and 2 because this deals with the facts. Number 4, I will take Your Lordship directly para 8 of the evidence, page 3, Your Lordship, because the earliers are with regard to the facts that was already taken place. If I may, that I say that the said application, because the application I'm referring to is para, Lordship may take up para 7. That I say that the second appeal bearing number such and such, the opposite parties on 31/3/23 as the appellant petitioner preferred an interlocutory application IS Civil 1095 by way of praying for grant of an order of status quo in respect of the suit land till disposal of the said second appeal. Para 8, that I say that the said application so filed by the opposite parties herein as the petitioner appellant being I such and such was heard and disposed of by this honorable court by this order dated such and such by way of specifically directing both the parties not to change the nature and character of the suit land till disposal of the appeal. The operative part, I'll just keep that here. Para 9. That I say, although the opposite parties were fully aware about the specific direction issued by the Honorable Guwahati High Court on such and such, an application filed by the opposite party themselves, the opposite party in total disregard to the said direction of the Honorable Guwahati High Court started to violate the same with impunity by way of not only carrying out construction activity over some portion of the suit land by erecting a house over the same, but also by alienating the same by giving the same on mortgage to third party. That I say that the opposite parties, after the passing of this order of this Honorable High Court, started carrying out numerous activities over the suit land, which have resulted in changing the nature and character of the suit land. I further said that while on 3/8/23, Amzad Ali, Sulman, and Akbar Ali started erecting bamboo structures, some portion of the suit land. Number 2, on 11/8/23, Sultan Sikdar Nur Muhammad has started clearing the grass and other vegetations which were growing upon the suit land by means of sickle, etc., by making the suit land ready for cultivation. On 24/9/23, Zohar Ali started plow and till some portion of the suit land by means of a tractor, and that apart such and such from 12/6/23 started to construct an Assam type house over the portion of the suit land by use of asbestos sheets, tarja wall, etc., and completed the same on 3/8/23. There are some pictures which were captured by my son, such and such, using his mobile handset, bearing this, showing some incidents of violation of the opposite party, along with pen drive of the said photographs, have been downloaded from the said and stored and exhibited by me to substantiate my statement, along with the certificate issued by my son in respect of the same under section 65B of the Indian Evidence Act. So these were exhibited before the learned trial court, Your Lordship. Now, Your Lordship, then I have, it has been stated that with regard to, these are the main violations that it was done. Now, if Your Lordship now takes up the cross-examination, interestingly, none of these statements were even contradicted during the cross-examination of this particular witness. the cross-examination, your lordship will find it was recorded on 13th of September 24. Your lordship will find these particular statements with regard to those specific violations, not a single question was raised or put to the witness with that these are false statements or these were not correct. Nothing is there. They totally went and did not put any question with regard to these allegations. If your lordship sees the statement, because specific dates, etc., were mentioned in those evidence, those dates, evidence were not touched upon. My house is situated in such and such. Suleiman Hali is such and such is there. The house of Nur Muhammad is situated in northern side. The house of defendant such and such is situated in the southern side of my house. The house of Saeed Ali is not situated over the Suitland. House of Nur Muhammad is situated. This I made Saeed Ali a party to the suit before he was encroached my land and constructed when Nur Muhammad. Your lordship will go through it, not a single thing with regard to the violations. These are all general questions which touches upon the merit of the suit. The suit was, we were the plaintiffs. Both the suits were declared in our favor. The suit was in our favor. The appeal, they filed an appeal which upheld the trial court's judgment. And this is there. Now, on this point, and similar was the statement of Sabed Ali, my son, PW2, the person who took the photographs. He had also deposed with regard to those violations and the pictures. Those pictures, etc., again in his cross-examination, not a single query or question was put by the appellants out here. They're challenging the veracity of those statements. Now, three witnesses state the same thing. Now, on this point, your lordship, I just want to draw your lordship's attention to your lordship's judgment, which your lordship delivered while sitting in a division bench, your lordship. 22. Oh. Your lordship may kindly see this particular. If there is no cross-examination on a particular point, I had marked the paras, relevant paras, which your lordship observation are there.
Paragraph number?
In the first page, your lordship, in pencil, because this, I thought they would be carrying the second copy. In the first page, in the corner, I have with pencil mark, it is there, your lordship, in the. Judgment will have.
So how many witnesses were examined?
Three witnesses, your lord.
And none of them were
No,
cross-examined
not
in
a
the
single
material.
question with regard to these points. They cross-examined all three, but with regard to violation, those specific statements which we made, not a single question in any of the evidences. Cross-examination was put to them with regard to that. There was no cross-examination on those points. Now, Another judgment of the apex court with regard to the same proposition your lordship had laid down while sitting in the division bench is para 40 of this particular judgment. Para 40 of this judgment of 2013 for SCC. That if they want to raise a doubt with regard to any statement, there should be specific queries to be raised in that. And another thing, your lordship, the appellants out here as the respondent in that particular proceeding did not step into the witness box. So that is also a point which I like to place on record before your lordship, because non-stepping in the witness box itself draws an adverse inference against a person, because a presumption under 114 comes into play, your lordship. 21. And for that proposition, I am placing this particular judgment. Para 18 of this judgment may be looked into. When the person does not step into the witness box, what
Paragraph number?
18 it starts, your lordship. And the relevant, it starts from 18 from the various judgments.
Paragraph number 18.
180, your lordship. From 18 till 29.
No, here, last paragraph is 17.
Last, it won't fully. Your lordship may take up this. From 18 it starts, your lordship. And the last, your lordship will find para 29, which lays down the proposition, your lordship. From Privy Council, the various judgments have been narrated by the apex court.
No, whether he has filed any objection petition here. No.
The court said that they did not file any objection, they participated out there.
Maybe. Then where is the requirement to reduce evidence by then?
Because on the very first day, if your lordship sees, well, it is a violation and this honorable court directed that I cannot take up this matter. It needs to be.
No, that's all right. But you cannot compel them to reduce evidence. It is their prerogative.
Yes.
Then where is the proposition that this violation order
Yes, sir.
is a quasi-judicial proceeding?
It is a quasi-judicial proceeding in the sense, it is not per se a quasi-judicial proceeding. What I wanted to say in the earlier occasion is with regard to, it is a quasi-criminal proceeding.
Quasi-criminal proceeding, yes.
Because why I was saying that?
No, where is that proposition?
The proposition is a judgment of the apex court, which says that because punishment is to, I will place the judgment, your lordship. Because a punishment, when a punishment, because under 2A, a violator is liable for punishment. So once it is a punishment per se, it becomes, that was the apex court thing, that it becomes a quasi-criminal because punishment per se is not a civil of similar punitive action is there. So when a punitive action is prescribed, it becomes quasi-criminal in that sense. I'll place that judgment, your lordship.
When?
Tomorrow I'll place it because they didn't bring, I don't know. I had asked them to bring that particular thing, your lordship. But why I'm saying it, And the court said that once it is a quasi-judicial, criminal, once a violator, because otherwise also the two sons are there. And only this case is with regard to the persons named there who have violated the thing. Now, even assuming appellant number 2 was a violator, then also violation, if he is a violator on his demise, the punishment to be imposed upon him will come to an end on his demise, because his legal heirs cannot be made subject to a punishment which he would have to be undergo. But however, the other persons who are there on record are to be liable for punishment under 39(2)(a). So merely of his demise, this proceeding cannot be said to have abated per se with regard to the other persons. So that is my concept, my argument, and I will place that quasi-criminal proceeding finding of the proposition. I'll place it tomorrow, Your Lordship. I don't know, they did not bring that before, Your Lordship. And here, another thing they had raised with regard to that they were in the cross-examination, one question was put, that when was the order communicated to the defendants, with the appellants? Do you have any information? For that purpose, 2005. Here, only one judgment I like to say, placed before Your Lordship, is with regard to the knowledge of an advocate, because here the order was passed of status quo in presence of both the parties. Now, that being so, the advocate on record who had appeared, that is Mr. Strom in this particular case, was aware of the order being passed. And Your Lordship will find in head note C of this particular judgment which I had placed on record, where it has been clearly stated that the representation of such parties by an advocate in a proceeding has implies presumption of such knowledge on the party itself. So the ingredients of order 39(2)(a) is that there should be a willful violation. Secondly, we have to place on record the date when the defendants were made aware of this.
So
Here,
knowledge of the counsel for the parties is the knowledge of the.
that is the proposition I want to propound, because here they are saying that particular status quo order was not communicated to them in the cross, not directly, but there have been question is that when was the order communicated? So that is not specific. They said that we do not know. But my contention is, Your Lordship, the day when a status quo order was passed by this honorable court in presence of both the parties, that both the parties should maintain status quo. If it was an ex parte order, it was my duty to communicate to the other side that an order was passed ex parte. And here, when the counsels representing both the parties are present before this honorable court, any order which is passed automatically is deemed to be an order which is on behalf of both the parties. If it is represented, the parties are aware of this. And for this purpose, this judgment which I have just placed on record is for this particular proposition of law, Your Lordship. And for that purpose, para 11, Your Lordship will find it. No, so not 11. Yes, para 11, the last. Here was a case of a dismiss for default, etc. But the last two lines, as the appellant is represented in the proceeding to his advocate, his knowledge of the order is presumed. I just want to draw, Your Lordship, this particular ratio, that once an advocate is there, anything which transpires in a court in presence of the advocate of a party automatically shall be deemed to be an order or any direction issued by this court, which is to the knowledge of the party itself, irrespective of the party not being personally present. So this I wanted to say before your lordship. And now with regard to violation is not a thing, because here it has not been controverted anywhere, and neither they have stepped into the witness box to give a different picture. So the contention of specific dates and names of the persons, even the 65B certificate, was not questioned by them, neither during the cross-examination. Not a single question put with regard to the video recording, pictures, etc., which we had submitted before the trial court in the pen drive. So all these factors remained uncontroverted during the whole cross-examination process here. So that being so, your lordship, and now again, I placed your lordship the pictures on the last occasion. Again today we have been informed that after that particular incident, they are carrying out and this was on 21st. That was on earlier, this is on 21st, this has been taking place. That is last Saturday. This is last Saturday's picture around 4:48. At the bottom is the tagline, your lordship. So on one hand, we had the suit filed by us, we were successful. The appeal filed by them, they were not successful. They come before this honorable court on a second appeal. The appeal was admitted, and the orders, the decree, judgment and decree were stayed. Now taking advantage of that stay, they are getting the benefit which they had already lost in the trial, your lordship. Now your lordship knows that in our apex court time and again is saying that the main purpose is during the execution, the difficulties arises. Here is a case, the person who was the appellant, after having lost, are still taking advantage of the leniency of this honorable court, and this they are, in spite of having filed an application under 39(2)(a) for the violation, they are with impunity, they are violating this, your lordship. So something, because the matter is fixed for final hearing, because it has been admitted, and the LCR, I think, has already been received. But if they, till that final outcome comes, these things are going to change the whole picture, scenario of the suit premises, which was initially for a cultivation. Now buildings are going on, construction is going on, your lordship. So many things are going on in the guise of an appeal being pending before this honorable court. And in spite of a status quo order being passed by this honorable court, this particular actions of the appellants should be, a strong action should be taken by this honorable court under the power of Order 39, Rule 2A. That is my humble submission, your lordship.
Okay. So, Mr. Sohan, you have no instruction regarding the photograph on the other day furnished to you?
My lord, photograph, my lord, showing photograph, my lord. Whether this particular photograph taken no picture of any person is shown. Whether this land or
No. I am not asking you to interpret the photograph. I am asking you whether you have obtained any instruction on the person to order of this court.
Yes.
What instruction you have received?
My lord, two type of delegation. Number one, that we flying the land. Yes, we are flying the land. And not think, my lord, after passing the order. But for long, my lord, we are all along, my lord, we are flying the land. So if flying the land, we are change the nature and character of the land. My submission is not at all to change the nature and character of the land. So far, the construction of houses is going there, my lord. It is they themselves violated the order. Because the direction to both parties, not a single party, direction is given to both parties. Kindly see, my lord, the deposition of PW1 summary. Cross person.
A government loan was given to me and I had.
Whether you have finished or not. Summary, my lord. I am not reading whole, my lord. 11%, my lord, middle person, kindly see, my lord. In the year 2014, Noor Muhammad constructed 5 number of houses over the Suitland, and thereafter in the year 2016.
You are reading cross-examination part.
Cross-examination of PW1, moral. Middle person I am reading, I am not reading whole. 2016, he constructed another house with tin shed, and after that he did not construct any house over there. It is their evidence. Around 1 year back, Honorable High Court directed both the parties not to raise any further construction over the Suitland and not to change any nature and feature of the Suitland. Thereafter, my lord, last 4 lines, kindly see me. In the year 2021-22, I was allotted house under PMAYG scheme, and accordingly in the year 2023, my lord, this is vital because in the order passed in the 23, I constructed the foundation of my house. Kindly see, my lord, they themselves violated the order. He summarily himself said that I violated and he constructed. And the road, my lord, shown in the picture, my lord, it is constructed by the summarily himself. And he filed this injunction violation against us.
Where is the suggestion? Nothing is there, your lordship.
When my house was under construction, defendant raised objection and accordingly construction work was stopped. So he then he constructed to some extent. And when we raise objection, then he stopped. It is a PW1, my lord. Can you see PW2? PW2 is his son. His name is Sabed Ali, son of Samar Ali. Last four line will put the case. I am the son of PW1, namely Samar Ali. My age is 24. In the year 2014, I was somewhere around 9-10 years of old. Since my birth, I have seen defendants are in possession of the Suitland, which actually belong to us. Honorable Guwahati High Court directed both the parties not to enter the Suitland for cultivation by any of the party. For cultivation, this my lord, the wrong you said it is not like that. Then my lord, a third person, Sadek Ali. I know all the applicant and respondent. I know Suitland measuring approximately 6.5 bigha. Samar Ali has his residential house about the Suitland. The brother of Ayaz Ali, namely Noor Muhammad, has constructed house over the Suitland somewhere around in the year 2008. Where is violation? I asking myself, where is violation? One is saying the construction was in 2014. And he again said that I constructed after getting my lord allotment of Prime Minister in the Awas Yojana. And he says, my lord, this third person said, my lord, in the year 2008, the house was constructed. Where is violation, my lord? And what is the order, my lord? My lord is saying, trying to say, my lord, that cultivating the land is violation. My humble solution is that the cultivating the land is not violation. So what is the order by Honorable High Court? After hearing both the sides, this court is of the opinion that till disposal of the appeal, the nature and character of the suit land shall not be changed by any of the party. There is no violation at all, my lord. And if there is violation, it is violation by Samar Ali himself. He himself admitted.
So according to you, cultivation is not amongst the violation.
No, no, no. Because, my lord, cultivation not change the nature and character of the state. I am not mortgaging, not selling, I am not digging any pond or anything, not constructing road, nothing of that sort. What construction was there, they constructed themselves after getting allotment for Awaz Yojana. Prime Minister Awaz Yojana. And they snap the picture, my lord, photograph and annex here and alleging that we violating. So for cultivation is there, yes, my lord. We are cultivating the land.
Reply. Lordship, I think they have filed a reply because this particular stand they are saying.
No, I am reading their cross-examination.
No, this particular stand they are taking, I think I've read it in this particular case before this honorable court.
So no case of my lord violation of injunction is made up. My lord, this proceeding may be resolved, my lord, and final hearing may be, my lord, any time may be taken, my lord, the final hearing, the case will be ready for final hearing. Because there was, my lord, a suit and contract claim also there. So there is two appeals. And choice of the matter is very simple, my lord. We produce they sell the land. We produce certified copy. We could not produce the original, but we prove by calling, my lord, book, a person from the register of things. That is the crux of the suit matter. We could not produce the original, and foundation of there.
It is there, Your Lordship.
This is the case, my lord. Simple case, my lord.
Objection is there.
Why still will accepted by Honorable High Court or not? That is the crux of the matter.
An affidavit in opposition has been filed, I find.
Yeah, this petition
Fayaz Ali has filed it.
earlier.
Yes, I have a copy. I don't know, it should be on the record. In IA 2546. The affidavit appears to be dated, Your Lordship.
Affidavit in opposition.
Affidavit in opposition. It is signed on 19th day of September 23.
Signed on 99.
1999, no?
Well, Honorable High Court cannot record the evidence, my lord. That is why the matter was sent for recording evidence. And they reduce evidence of three cases we cross-examine, and this is the cross-examining.
They have also admitted there that they are cultivating the land.
Yes. They are cultivating.
Okay, Mr. Biswas, on Thursday you produce that decision of
Yes,
the
I will, yeah, I will try to just get it now also if I can place it before this judgment.
One thing more minor. One thing more minor. My friend to satisfy the honorable court, the cultivating the land is changing of nature and character of the suit land, because this is the order. How cultivating the land, cultivating the particular land, it will change the nature and character of the suit.
No,
This
no,
is the
the
crux of-
photograph shows some construction work there. The photographs they have produced shows some construction going on there.
Yes, they admitted that they constructed. Someone himself admitted by Lord after getting the allotment of the Awas Yojana, he constructed, he admitted in the procedure.
I will place that, yeah.
Okay, on Thursday you produce it.
Yes, I can produce it now, yeah, but I'll just take it out and copy and I'll send it.
Okay, then after vacation, already a lot of cases picked
Yes,
on
sir.
Thursday.
And the
Yes.
date may be fixed because
We will fix it at hard business, but at counsel for the applicant. And also hard business one, learned counsel for the respondent. Hard in part, place the matter on.
highly obliged.